Milord, we would like to mention one case that is 498 of 2026 filed on 7/1/2026, that is Samuel Shah versus Union of India and us. In the GST department has started their proceedings and uh, uh, taken their banks in seize, so they are not able to operate any banking and facing a huge
Why don't you
financial.
prefer appeal against the adjudication order?
Yes, we have already submitted that, and
You have preferred appeal before the appellate authority?
yes, it has been done already. After that, the proceedings happens, and that's why we have filed a writ here.
Despite putting in 10%, they are doing that.
Yes, my lord.
But you may mention two matters. One is, Lordship, the cash seizure matter. After 14th of January, your Lordship had directed 2 weeks to them, 1 week to me, and then the matter was supposed to come into the list. But neither they have filed any affidavits also, Lordships, and it is not in the
list.
And one matter, Lordship, Mr. Devashish Ghosh was leading me in this matter. This was that Arunachal Pradesh, the Itanagar. So, as per the order, Lordship, it is returnable today. And the opposite side is led by Mr. Arijit Chakravarti. Your Lordship, I indicated if both sides are there. Today, serial 883, it is there, Lordships. But it is not fixed at 2 p.m. The Lordship has indicated on the. But there is no order, last order.
The urgent motion is there.
If Lordship can take this, I will then give a notice to the other side.
এটা আর্জেন্টে আসার কথা ছিল তো, কালকে তো দেখালেন, বললেন আর্জেন্টে থাকবে, আবার নিচে চলে গেল কি করে? কালকে তো
1785 of 26.
কালকে তো দেখালেন, বললেন
883 today
থাকবে, আজকে আসার কথা ছিল, কালকে তো তাই বললেন, কেন রাখলেন? বললে তো হবে না, লিস্টে তো আনতে হবে, ওরা তো রেডি থাকবে না। It is appearing under an absolute wrong heading.
It is appearing under Lordships.
Assigned
matters.
No, it is not an assigned matter. It is a specially assigned matter in bulk.
Lordships. It was from Justice Honorable Justice Amrita Sinha.
Yes, I know. হ্যাঁ, তো ওটা তো স্পেশালি অ্যাসাইন্ড ম্যাটারের হেডিং এ ছিল, অ্যাসাইন্ডে কোথা থেকে চলে গেল? ভুলভাল করেছেন। কালকে দেখালেন, কথা বললেন, তারপরে আবার এইরকম।
Item number
Friday under the specially assigned matters.
That Lordship will take first.
And we take first.
Get much. I serve a notice.
Your Lordship, this item is appearing at item number 597. Lordship, the urgency is that, Your Lordship, in this matter we have challenged the adjudication order because we have not been given an opportunity to be heard, Your Lordship. By the time we got to know that there is an adjudication against us, Your Lordship, the time for appeal has already been passed, Your Lordship. We have not got any opportunity to be heard, Your Lordship. And the urgency is that now they are pressurizing to pay the demand amount, and have to my bank can be seized at any point of time.
Please give, I shall see. It will not appear immediately.
Lordship, for inclusion.
So I am just praying for inclusion in the list, my lord. Under the heading hearing, my lord. Hearing.
Kindly mention, hearing list item number. Here, I am challenging the entire search seizure under section 67 of the GST Act without jurisdiction. Your Lordship heard on 10 December and time for filing affidavit expired 10 January, my lord. I am praying for taking up 3 matters, my lord.
Please wait a little bit, Mr. Rai. You see this condition of the list, unnecessary inclusion. I'll not be able to reach. Please wait for some time. let those who have not got chance at all get a chance, then mention.
My
lord, I have mentioned correction of first title.
দিয়ে দিন, correction দিয়ে দিন, yes. Give it. I said inclusion,
Your-
new motion, please don't mention, give it. Just give this please.
Your Lord, Your Lordship, this matter is for urgent hearing. The petitioner has been receiving final notice of outstanding payments, and as a small tradership, the petitioner will suffer irreparable financial harm if she is not heard. So it's basically the regarding the income, the input tax credit for the retrospective cancellation of a
দিয়ে
supply.
দেখে দেখে।
Your Lordship, may I be allowed to mention for the urgency, like the registration has been cancelled.
On what ground?
Actually, registration has been cancelled.
Registration cancelled on what ground?
It is already, Your Lordship, in the list for 546.
Madam, registration cancelled on what ground? If it is only for non-furnishing of returns, I can upgrade it. If it is for different grounds, you'll have to wait. Yes,
my lord,
you have seen it. If it is not there, I will send it out of list after upgradation. If I
my lord,
find
for
it.
upgradation we are applying because there is a,
Check it and mention.
my lord, there is a bank
Check
attachment.
it and mention. Please check it and then mention.
In the meantime, Your Lordship, please, one more for the extension of interim. order.
Extension of entry model, please give. Yes.
My lord, I'm praying for upgradation of the motion because there is a bank attachment, my lord. Already.
Please wait for some time. Let me finish some motions. Yes, call Kurun. Yes.
Ma'am, for the applicant, ma'am.
Yes, Mr. Das,
My
there
lord.
is a problem. The problem is, you see this list which was published on the 6th.
My lord, I have mentioned your lordship on it. That day, my lord, the number wrongly.
The CPAN is appearing, that is why the order cannot be uploaded. I'll have to pass an order to correct the database so that the order can be order has been rightly typed and signed,
My lord.
but the WPA number
Yes, my lord.
indicated in the
On
list
the
is
very
wrong.
date I have mentioned your lordship, my lord.
This matter, এটা correction টা কি Yes.
See, my lord, this has been placed before my lord upon being released by Justice Sarkar. My lord, it has appearing as to be mentioned. We can pray, my lord, jointly, my lord. Fix it any day, we can do it. But as an officer of the court, my lord, I know, my lord, my learned senior friend may object, may not. But it's my duty to point out, kindly turns to opposite party number 6. My lord, it should not happen that later on, after completion of
I have
hearing,
no
it comes to notice. My lord, we have no objection if my lord doesn't have objection. We have no objection.
No objection.
Justice Sarkar
But
has
finally
released
have to
order.
hear it, but otherwise, my lord, what happened, my lord, they also file an application under section 25 for transfer of the suit. Now, these things will be taken as a ground to the Supreme Court for transferring the suit itself.
That's why, similar on the last round of litigation, at least 4 benches has released. Then Justice Bhivash Ranjan, they heard the matter out. Now, my lord, Justice Sarkar has released. If my lord has no problem, we do not have any.
I have no objection, no problem. He's having
On merit, I will argue. But my lord, firstly, my lord, first comes to first, my lord, I need to point out this. Opposite party number 6.
number 6. That's why I was saying, like, opposite party number 6. I am not mentioning the name.
And that's why I'm not mentioning that. We all know him.
It will be difficult because later on, if some problem arises,
Not so far as both of us concerned, my lord,
We have no problem.
no problem.
We have full
No,
faith.
absolutely no problem.
We have full
party
faith.
suit. It
Party
is not only one party which is going to be affected.
Huh.
That is the problem. Problem is maybe both of you don't have a problem, but the other parties who are there in the party
I'm
suit
sure,
will
my lord, opposite number party 6, number 6 has also no problem.
opposite party number 6 will not have a problem, but the other
Other opposite parties have no problem. We are all represented.
take
We are all
My
represented.
learned senior friend representing all must be.
Hmm.
So, shall we go?
So all plaintiffs will not are before your lords. The opposite parties are.
we have to be very, very cautious here. We are in a very vulnerable position actually.
That is up to your lordship, lord. I am not saying anything. But so far as we are concerned, we have no
We have
objection.
no objection.
Actually, I am also releasing it. It will be difficult, unnecessary.
To hold. Four, 5, 6. 4 is the against.
Number 4 only.
We know. As per your lordship direction, they have filed the report. Only 1 page I will show. Dekhi. Only 1 page I have shown the report. Page 11 of the report.
My lord, I am for the respondent, my lord.
Late by man.
He is online.
Yes. Well, kindly proceed.
Page 11. Very.
Why are you appearing online, Mr. Bhattacharya?
But some problem today in the morning at my house, my lord. That's why, my lord, arose. That's why I couldn't, my lord, come to in time. That's why I thought, my lord, I will not attend your lordship, my lord. That's why I'm compelled to join online, my lord.
Yes.
Page 11, table D.
Table D.
Yes,
Yes.
that there are details of the overlapping common supplier, demand confirmed as per OIO, CGST authority, as well as SG authority. This is a common. Next, from the above table D, it is evident that the certain ab initio non-existent supplier are common in the both the adjudication orders passed by the state tax authorities and in the order dated so and so passed by the CGST authority. However, it is submitted that this overlap could not have been examined or factored by the central GST adjudicating authority at the relevant time, as the petitioner failed to disclose or furnish the copies of the show cause
So
notice.
it is admitted that there is an overlapping and
Yes.
in respect of the same subject matter proceedings have been initiated by both the
Central
central as well as the state GST authorities.
thing is that at that point of
But my
time,
lord, my lord, they did not raise any whisper when they attend the hearing, my lord. They even didn't file the reply, did not say.
What is the Mr. Bhattacharya, what is the recourse now available? Now suppose this has been done. So can it
Your
be
lordship can
permitted?
set aside the order, remand it back to the authority to adjudicate, my lord.
It cannot be so that both the authorities will have the order.
Yes.
Any one of them has to choose who is to do it. Ultimately, who is to proceed with the order. So why don't you take a call on this? Who amongst you will proceed? And if you are unable to take a call, then in that case, the order which was passed by the first authority upon first initiation, that will have to be tested. Because that is what the ratio of the Honorable Supreme Court is, that both of you amongst yourselves will have to decide as to who is willing to proceed. Now both of you have proceeded and both of you have finalized also. Who is going to go ahead with the order? Because then in that case, it can be so that the authority which first proceeded with the order, that order will be sustained, and the authority which later proceeded with the order, that order will have to go. That can be a way out. Ticklish situation.
Yes.
Well, this is a Supreme Court decision is armor. They said this is a overlapping. The second show cause notice will be quashed. That is a clear words.
This is what I said just now.
Number one. Number two, just
the proceeding first in point of time, which has culminated in the order, that will remain. The later one will go.
Yes.
Because while armor was being considered by the Honorable Supreme Court, none of the proceedings had culminated in an order. Now there are two orders.
yes,
One passed by the state, one passed by the central GST authorities.
yes,
Both have reached finality.
yes.
At such point of time, it is being pointed out to court. It was not taken before the authorities concerned.
No, that is a factually incorrect. Actually, friendship, very frank, I am lordship. This is totally factual. What my learned friend said. I can show this later. 2022, I have informed them. They have not gone through this. We have said the show cause notice.
Where is that?
Page 151.
Page 151.
Volume 1. I have said the investigating authority. Page 151. To the so and so Ashok Prasad, DGGI. That is second paragraph. In this regard, it is submitted that show cause notice so and so dated 24/2/2020, hereinafter referred to the show cause, have already been issued under section 74 of the WBGST Act on the same allegation for the periods 2017-18.
Yes, Mr. Bhattacharya, this letter was written to you.
And that is show cause.
As per my instruction, my lord, as I have seen from the order in original, my lord, you also find, my lord, they are, in fact, my lord, they have submitted only one application saying that the writ petition is pending. Therefore, you please keep this adjudication abeyance.
No, but this
That's
is
only
dated,
clear.
this is dated 15th of March 2022.
That is so, my lord. That is so that now I have seen. But question is that as per the order in origin, also the instruction said
How was this
they, my
letter
lord, they
served, Mr. Das? Mr. Das, how was this letter served?
That is, we have said 152. 152. And they have admitted in the reply to show cause notice. We have said these things.
Where?
Reply to show cause notice, দেখা আছে? কোথায় reply to show cause notice আমি mark করেছি। সব মুছে দিয়েছি। হ্যাঁ। না 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 রিপ্লাই অ্যাডজুডিকেশন অর্ডারে ছিল তো এই তখন তুই সেদিন দেখালি রে
দেখালাম তো
পেজ 72 অনওয়ার্ড পেজ কোথায় রে? হ্যাঁ আমরা বলেছি তখনই দেখিয়েছিল actually last occasion I have read Mr. Bhanjo also shown this thing that we have informed him.
They have stated that we have filed a they have filed a writ petition against the show cause notice.
No, no.
But in our specific is that when they have informed us that there is a show cause notice by the state GST authority, we have specifically requested the petitioner to submit some documents to show that yes, this is the supply against whom that show cause notice has been issued. They failed to do so. This is also, my lord, specifically stated in our order in original. What is also in our instruction, my lord, the authority also stated that they failed to provide the instruction. Otherwise, they should not have proceeded with the matter.
My lord, when I have given the show cause notice, if they have
Where show me where in the reply to the show cause where you have mentioned. That is what I wanted.
152
they did not file any reply, my lord. They did not file even reply.
No, we have said personally and they said had not submitted the reply to the show cause notice. We have said this thing.
You have not filed any reply.
154 also another letter. 154A, lordship, kindly look at. Kindly. And this letter has gone 152. 154A. 155A.
But how was this served?
The second paragraph. In this regard, it is submitted that
there is no proof of service of these letters.
This letter, this is 152.
152 is only proof of dispatch. You have only attached the postal receipt.
Yes.
Nothing to show that it has been served. This is only sent.
Huh.
Postal receipt is only
Oh,
proof
so
of
cause
dispatch.
notice we have served, whether we have served.
Where have you indicated that yes, it was being taken up by the state authorities also? This page 151 that you have indicated.
And 155A.
155A, there is nothing. 151, there is a document to show that it was sent at page 152, but whether it was received.
That is 152.
Page 152 is only postal receipt.
Yes.
Track record is not there. We don't know whether it was received by them or not.
That is not dispute. That is they have in
it
the
is disputed. They say that they don't have, they were not informed.
No, that is in the
page 173, my lord. 173, my lord. Page 173, para 9.3, my lord. Para 9.3. In view of the whereas Form GST DRT 01 Part A under Route 142(1A) was issued to Messrs. GS Pigment for compliance of 17/5/2020. In reply above, to GRC 01B dated such and such by the notice.
So they have submitted that.
Yes. Now, thereafter, my lord, kindly see page 174, my lord. However, the notice have not submitted the copy of show cause notices mentioned above. Further, letter dated 12/4/2022 and email dated 1/7/2022 have been issued to notice to provide the copy of show cause notices issued by state SGST authority West Bengal, but the notice have not submitted the same till date. So this is that, my lord. Therefore, my lord, department has to proceed.
Assuming he is correct. When I have given the intimation, they could have take the copy from this all these inquiry. That is the point.
My lord,
that is the Supreme Court.
The burdens upon the revenue.
I am not saying
that is the
armored security, my lord. But that guidelines come. Our order is
retrospective. That is
there was no guideline. If somebody the SSC has indicated to you that there is a proceeding pending, then you are proceeding at the peril of the proceeding being fought.
Yes.
If it is if the result of continuance is so dangerous, then it was all the more important for the officer to check if he is not cooperating, because he will then keep tight. He will know that ultimately it will be cost. Your endeavor will go to range. So it was your duty that if this is pointed out, I should take steps immediately to see whether I am proceeding. All this exercise will ultimately go in vain. That is why it is important. That is why the Honorable Supreme Court
Yes,
said that.
subsequently, my lord,
Yes,
the
Lordship. When I've given an intimation, they could have inquired.
The intimation is given, you should inquire for your own benefit.
Yes, yes,
That
Lord.
your time will be saved. Somebody else is doing it. Unless you say that no, you should not, I will do. Then in that case, if there is no consensus arrived at, the one which was started first will continue.
And Supreme
So,
Court has
in this case, all the all the issues were covered by the show cause notices, or some of the issues were.
all these issues, and that is admitted their report.
supplies of non-existing existing bogus ITC has been able against them. That, my lord, if your lordship kindly see page number 11 of the report.
All these show cause,
that,
Lordship,
all the supplies are
existing, non-existent.
supplies are mentioned. If your lordship kindly see page number 11, paragraph number D. Paragraph D, table D, is number
D.
11. The details of overlapping common supplier demand confirmed for order
They are
original.
one to eight. So
Yes,
they-
my lord.
in
These are covered by that appears
All
from
one
the,
to
if
eight.
your lordship kindly come to page number 10, that table of that demand against that supplier that is narrated in table number, my lord, if your lordship kindly see page number 10.
Seen it.
Even from page number 9, table A, table B.
And where is Mr. Day? Mr. Day was also appearing. He
No, my
was
lord, Mr. Senior advocate Mr. Dipul Kundoli against him for Union of India.
in another matter he was there.
Another matter.
This proceeding was initiated later on.
Yes, Lord.
CGS.
Yes, admitted. Admitted. First show cause notice by the state 24/2/2020. Second show cause notice by the central 26 July 2022.
Very well. I'm keeping it on Monday. I will go through it.
As your lord.
I'll then pass orders on Monday in court.
As
order.
your lord.
You have any problem?
Yes, my lord.
Heard Mr. Das, learned senior advocate appearing for the petitioners, and Mr. Bhattacharya, learned advocate, appearing for the respondent CGST authorities assisted by Mr. Bhonjo. Full stop. List this matter once again under the same heading on Sombare date the
Only Tuesday.
Monday will be better.
I will pass my orders.
Only my lord.
You will be in difficulty.
No. I am coming.
No difficulty.
No difficulty.
On February 16th, 2020. 16 की है
Monday. Should I give the chart already?
I've
Already in 5. In the record it is also. And
No,
Armor
there-
also record.
I'll just go through the documents once again, because unnecessarily if I start passing orders today, it will take half an hour.
Yes, my lord.
I'll consider the armor security judgment
Yes.
also.
No, their report is very good. They have said everything recorded.
That is why it will help.
Grateful, my lord.
Monday.
My lord, my lord, grateful, my lord.
Yes. So this 5 and 6 we are simply adjourning. Simply adjourn. 5 and 6 will have to be tested on merit if this 4 goes. Yes, Lordship. Because then 5 and 6 will be a contest.
And there is a higher amount. There is a central tax is a 2 crores and here there is a 5 crores. So I am taking responsibility that I will fight for 5 crores.
Yes.
May it please, Lord, that I am appearing for the petitioner in the matter. Lord, instead of wasting the honorable court's time, because this is that matter, my lord, where we had mentioned and it was, my lord, heard on the last occasion with regard to, my lord, the time limit.
Yes, yes.
My lord, I have also gone through, my lord, in details of after what has fallen from your lordship, and I, my lord, concede to the fact that it will not be a time barred, my lord, directly because of, my lord, the subsequent decision in Rajiv Bansal. Now, my lord, from the petition, I have called out 5 separate points, my lord, which I want to argue. But without a note, I think I'll be consuming the court's time. But I want to indicate broadly the 5 points which I'm going to argue. But I'll prepare a note, I'll come, I'll place the notes and I'll argue.
What is your point?
But first point, it's a 2014-15 Millard proceedings. The first point is that once, the 149 time frame that we are looking at. Today, if your lordship kindly takes up the Ashish Agarwal's decision.
Your order was passed when?
There are 3 parts to it. There was
assessment order was passed when, Mr. Bag?
2023, Millard.
2023.
16/5, 2020.
And your petition was filed when?
Thereafter, there was a 2024. We had on 22nd March 2024, 271 notice came in. It is immediately thereafter that this petition has been filed with the pleading.
When the notice came when?
The notice
22nd March 2024.
My lords. 16th May was the order, my lord. 16th May 2023 was the order.
Mr. Bag, it's grossly delayed. On that
ground
alone, I'll not interfere.
We have stated, but there are 4-5 points here. May I only indicate then?
Not satisfactory. You approach the appellate authority. You try to impress upon him by
then may
Section 5.
Lordship.
No, Mr. Bag.
I understand what is falling from your lordship. May I only indicate the points then?
Because I see the notice of penalty, imposition of penalty,
Lordship,
was also at least 2 months prior to the date when you approached this court.
That is because we have
in any case, even that is after the period of limitation prescribed for preferring an appeal against an order of penalty.
Indeed.
So,
may I only indicate 3 points?
Facts, Mr. Bag.
Only 3 points. I'll not trouble you, lordship.
Wasting time, Mr. Bag, because this.
I'll only indicate the point. I'll leave it to you, lordship. Only this part. 5 minutes. I'll not take more than that. First point, my lord, is because Ashish Agarwal, the judgment has held that this notice then should be treated as a notice under 148A(b).
All points taken to you. Take it before the appellate authority. I'm not entertaining the petition because there is an appellate remedy, assessment order passed. You have approached the court long after the appellate remedy also was not available to you.
One point I'll argue and then I'll leave it, my lord. One is, my lord, that if it is to be treated as a 148A(b) notice, then, my lord, consequentially, we have a 148A(c), which is my right to give an objection, and a 148A(d). Now, that has not been followed, my lord. Your lordship will kindly note, my lord, without, my lord, on the point that I did not know about this, my lord, proceeding at all, if your lordship kindly sees the date, 2 points I have, my lord. One is this, and the second point is, my lord, change of opinion, because in a 143(3) proceeding, I'll quickly indicate the page, my lord.
Will be available to you before the commissioner also. So, all these points will be available to you before the commissioner appeals also. It's not that I'm closing it. I'm just saying that I will not interfere because of the delayed approach to court. You could have approached to court even in.
We didn't know about this. That is the difficulty.
That you inform the commissioner will also be absolutely within jurisdiction to set aside the assessment order if the commissioner feels.
Then I'll not trouble your lordship anymore because these are the points I have, my lord. Nothing more than that. May I only pray for this, my lord?
Mr. Bag, if I start entertaining.
No, I understand that. No, I understand that. There is one difficulty which we had, so I don't have, I can't improve the facts, but these are the points I would have argued. One, my lord, that 148A(c) has not been done, D has not been, my lord, issued. Next point was, my lord,
and yes, Mr.
change of opinion.
Just to honor his submission, why did you not follow the 148A procedure?
Yes, that's my case. This is not the.
57.
In fact, 56 there's a chart. 56 a lot of people find there's a chart. That is my case that I've never received them. Because the officer handling it was not, he had passed away.
148A procedure was not followed.
Not followed.
ABCD. Because this is the.
And there's a post pilot, Ashish Agarwal.
He says that it is post Ashish Agarwal. So therefore that procedure ought to have been followed.
That's not followed. And this is a point which the law remains the same.
That is.
We had filed this petition in 24. It's an old petition. 24 petition.
You go before the appellate court.
So may I only pray for an indulgence, Lord, if your Lordship, Lord, grants us that liberty, instead of filing a section 5, which invariably will be rejected.
I'll exclude the period during which the writ was pending.
I'm very grateful, my Lord, so that we can approach within a certain period of time.
The writ pendency will go and you can approach.
Within a certain period of time, my Lord, but my Lord, kindly don't leave it to the, my Lord, authority, because otherwise we'll.
For the balance period, you will have to explain. 2024, July 2024 onwards, till the date of, I'll indicate 14 days or 15 days, whatever time I give.
My Lord.
The entirety of that will be excluded. From May 2023 to July 2024, you will explain that. You will have a lesser period to explain. You have your explanations here.
Not.
I'm not dealing with the adequacy of the explanation or sufficiency of the explanation that we have provided for the writ.
Because we have a good case on merits also, my Lord. I can show that change of opinion also is a point. Lordship. Lordship. Oh, my Lord, may I only pray for this? If your Lordship, my Lord, condones the delay and indicates that this is the, my Lord, period, and my Lord, then they can consider it on merits. I leave it to your Lordship completely, my Lord. No, not only this period, my Lord.
That I will indicate.
I'm only.
That I will indicate, and I will say that he will consider it appropriate.
If it is filed within a particular period as directed by your Lordship, my Lord, then if they can condone that and they can proceed with the merits in the matter.
I will not condone it.
My
They will condone it. If they don't condone, you have remedy.
My Lord, I'm very deeply affected.
This
And the scrutiny of return stated the reason for denial of ITC is the
Yes, where is Mr. Chakravarti? You are supposed to argue, isn't it?
I would ask
You are asking. Yes.
your lordship, without wasting further time, your lordship, point was that regarding point number 4, there is a specific point number 4 regarding HSN. They have submitted all the replies. That has not been considered. May I take you briefly with what has been considered and what has not been considered? So it is very essential. Just I leave it to your lordship to decide whether the adjudicatory authority at all has decided or not. Lordship, your lordship kindly come to page number 217, your lordship.
Page?
217. Try to keep it as brief as possible. 217. Point number 4.
217, point number 4.
From e-way bill details, it has also been observed that there was only one HSN code mentioned in all above movements document in question, which is 39206929, and all movements have taken place without changing the nature of goods. Hence, prima facie, it transpires that the invoices and the e-way bills have been generated without any movement of actual goods in order to enable the buyers to avail ITC. As per common postal data, Matashri Snacks Private Limited, GST Control, is the seller of the goods bearing HSM this. The instant RTP printographics used with the goods bearing HSM this and this. The goods mentioned in the e-way bill is completely different than what the supplier, the Matashri Snacks, actually dealt in. So this was that HSN has changed or not. Then after that, his submission, your lordship. If I may take your lordship to the submission. It's at page 254, point number 4. 256. Start on 256.
Yes.
13.1. 256 is the query. Point number 4 is the query which has been.
Yes.
13.1. Next page 257. It is essential to understand the goods dealt with RTP printographics undergo a lamination process before the movement. However, this process does not alter the fundamental nature of specification of the product. The good remains consistent in their utility. Then after that, so and so his reply was there. The documents which were submitted by him were in 259. Transporter for establishing physical movement of the goods,
Yes.
transporter records, delivery acknowledgement. These were the documents. How the adjudicatory authority dealt with it. Your lordship kindly comes to page 53, 58, 50, 58. Fine. 58.
Yes.
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 58 in paragraph. Your lordship, second paragraph. Upon going to the submitted reply, it reveals that the RTP has tried to establish the whole transaction of the goods having HSN so and so as common business practice for cost effectiveness, but in spite of providing ample opportunities, no above mentioned transportation document would receive no. Against transporter copy, he has provided duplicate copy of invoices for transporter, but not without any good receive no. The outward supply documents against the previous inward supplies and the supplied goods bearing same HSN and circular trading have been provided against the various transactions with other RTP mentioned in the scope. After that analysis part, it is pertinent to mention here that without corroborative evidences from the part of RTP regarding the fate of purchased goods and subsequent tax payment against the related outward supply, the actual motive of the trade practice cannot be established. Again, this is relevant to mention here that the burden of proving that the ITC claim is correct lies upon the person claiming such ITC. burden of proof that ITC claim is correct is solely upon the accused who has to discharge the burden. So it talks about, after that your lordship, the dealer claiming, skipping 2 3 lines, dealer claiming ITC has to prove beyond doubt the actual transaction which can be proved by furnishing the name and address of the selling dealer, details of the vehicle which has been delivered the goods, payment of freight
He
charges,
has supplied the details of the vehicle.
but he has not supplied other acknowledgement of the delivery goods. Few other
No, they have
documents,
supplied a lot of
I have
documents.
received the goods. So what acknowledgement? I have received the goods.
but he has to supply other documents also from
What
his
documents? Whatever documents they have supplied, where is the discussion as regards that? Why those documents are not sufficient?
sufficient enough. Your lordship, whenever those documents are not sufficient enough, we are entering into the merits of them.
So that has to be spelled out. We must know the reason why those documents are not sufficient enough. I am not entering into the sufficiency of the document. But we have to spell out that these documents are not sufficient enough and why those documents are not sufficient enough. Where is the why?
Your lordship, the documents according to various to the selling dealer
And what is the answer to that point? You have taken into consideration somebody's evidence, drawn adverse inference on the basis of that, and you have not supplied him that.
because he has submitted the email at eBay bill at the later stage.
That may have been, but once you draw adverse inference on the basis of somebody's evidence, you will not supply a copy of that evidence because that has factored.
That I cannot.
So on that ground alone, without discussing anything else, sending it back, let him pass the order upon.
I just want to submit to this particular part, my lord, the burden of proof part and the documents which he has. My lord, kindly have a look at section 155 because he has referred to section 155. Now, this is a point of law, my lord. The interpretation of 155. Well, where any person claims that he is eligible for input tax credit under this act, the burden of proving such claims shall lie on such person. So, what it talks about is when I claim that I am eligible for input tax credit, then the burden of proving lies upon me. Now, the burden of proving will lie upon me in accordance with what is provided in section 16, read with documentary requirements, which is provided in the rules. The section says that what are the conditions to be satisfied. Rule says what are the documents required for claiming.
There, Mr. Saraf, I would join issues. The rule says what are the documents you would require for the purpose of claiming eligibility to or for the purpose of being entitled to claim ITC.
Correct.
That is what the rule says. Now, if the authority questions you, then something more than what is prescribed there for just being eligible is required to be proved, because then you have to answer the pointed question which has been raised by the authority.
What I am
So therefore, that would not suffice for the purpose of discharge of the burden.
No, my lord. What I am submitting is that kindly just have a look at rule 36.
It is as easy as this, Mr. Saraf. Somebody questions me, what is my identity? I prove my identity card till such time that the identity card itself is not questioned, my identity will not be questioned.
Correct.
But if there is some procedure by which I can question, somebody can question my identity card, then I will have to prove by documents other than the identity card to show that yes, I am the same person who I am claiming to be through the identity card. Therefore, merely because we have to satisfy 4 parameters to claim ITC, satisfaction of those 4 parameters would not lead to discharge of burden. Yes, it may shift the burden upon the revenue once you show these 4 documents. But once the revenue bounces back with something more than that, the burden still remains on you. You have to discharge.
No, my lord, I will make one small submission on this. The revenue
on this it can go back only on the point of
no, my lord, just give me 2 minutes, my lord. I will not take a lot of time. What I'm submitting, my lord, that they can always question. I'm not saying that their right to question.
Right.
What I'm submitting is that what they are questioning, my lord, it cannot be arbitrary and it cannot be on the basis of, my lord, the suspicion. My lord, there can always be a doubt. He can always create a doubt that this is doubtful. Now, whether that doubt can clean board the SSC, in cricketing parlance, but the benefit of doubt goes to the batsman, not to the, and in the taxation laws, the benefit of doubt always goes to the SSC, not to the department. I can show the constitutional bench judgments, which have repeatedly held that the benefit of doubt will go to the SSC. Now, here, how he is creating doubt? First, he says that the HSN are same between transaction between 3-4 parties, which is, I clarify that they are different stages. All items are classifiable under chapter 39 because chapter 39 encompasses raw material to various articles of plastic. So everything is classifiable under section article 39. So then he moves away and then he says two documents mileage is asking me to submit: payment of freight charges and my lord, the consignment note. I have answered in my reply that consignment note is not in my possession because the delivery has been done by the supplier. My lord, where the law says, my lord, that is why I was saying, my lord, kindly have a look at section 16 once, my lord. Section 16 2B.
Section 16 2B.
2B.
Yes.
But it starts with negative connotation. No registered person shall be entitled to receive any unless I am in possession of the invoice. A. B. He has received goods or services or both. Now, explanation. For the purpose of this clause, it shall be deemed that the registered person has received the goods, or as the case may be services, where goods are delivered by the supplier to a recipient or any other person on direction of such registered person, whether acting as an agent or otherwise, before or during movements of the goods, either by way of transfer of document to title of goods or otherwise. So once the supplier delivers it to me, either to me or to my agent, it may not be in my registered premises also. It may be that I am asked him to deliver directly it to my job worker, directly to my customer, because that is also the mode of business, my lord. So the delivery can be done by the supplier. The law does not say that I have to get the deliver goods to myself by my own vehicle. I have to engage the transporter. I have to make payment of freight to the transporter. Now I have written in my reply that you please ask for all these documents from the supplier. He is not dealing with that. If it is not in my possession, how do I furnish something? Can an impossible burden be imposed?
I'm sending it back. We will reconsider it. You will also get it.
Kindly, just make an
I will not enter into merit because it will unnecessarily create trouble.
Kindly send that. Because I cannot defend that point which
That
Lord
is
has
different.
raised. That is very difficult.
That this case they examined, examination in chief, I would say, the owner. So all my lord, I'm requesting just my lord kindly make a observation that they should examine the broker and the driver, my lord.
No, I will not say anything else. Whatever they do, they will have to provide opportunity to you if you want to cross-examine. If you want to cite witness, you cite. You will be entitled to. You pray for whatever you feel.
But with respect to my lord, the burden of proof also there is judgment of this
Not
honorable.
required. Why? I'm sending it.
So with respect to burden of proof, my lord.
Show me. What it was show me.
Lot of judgment.
No, my lord, the difficulty will be I will keep, my lord, this will keep, my lord,
It has to because
rotating in the.
writ court will not end it. It has to end with the fact-finding authority, which is not the writ
No,
court.
my lord, the difficulty
The remedy
is
will be
that
if
the
you
fact-finding authority goes into
You
realm
will have
of.
to get it. You will have to get it because all these issues, if I start deciding here, everybody will be in bliss, including the appellate authority and the tribunal. Let us not
And the
convert the writ court
difficulty,
into the
my
appellate
lord, the
authority.
difficulty with the.
We will only test procedural impropriety, and that is what we are supposed to do. It is well settled now, right from the origin of the Honorable Supreme Court, that we test only the decision-making process. The soundness, legality, effect of the decision is not to be tested. Even if the decision is wrong, the decision-making process is right, I will not interfere. There are judgments as recent as 2024 to this effect, and that is settled.
Yes,
Even if the decision is wrong, I will not interfere if it can be shown to me, because I'm not an appellate authority. I'm not sitting in appeal. I'm only testing the procedure. Whether
But
the
I am
procedure followed is fair or not. I
I'm
find
just
it unfair.
urging your lordship to enter into the point of law, whether what kind of documents they will.
Difficult in a fitting case. Here I have a smaller point through which I can get round. I will give others a chance to plead their case.
Just
Yes,
on the burden of proof, paragraph 12, my lord, I am referring to.
paragraph 10,
12.
12. Yes.
Although Mr. Siddiqui he has come to our side now, has strongly argued that the burden of proof lies with the petitioner number 1 to prove that the goods had been moved, and the petitioner number 1 has failed to discharge the burden. I would rather notice that in the instant case, the petitioner number 1 had discharged its initial burden in establishing the sanctity of the transaction by placing the e-way bills, which were admittedly issued through the respondent, the invoice, the bank statement, form GSTR 2A, which in no uncertain terms should demonstrate that during the relevant period, the petitioner number 1 supplier had filed his return, and it proved conclusive.
I will make an observation because I have also indicated to him that he has to first spell out why the documents which have been supplied by you are not sufficient.
Yes, my
I
lord,
will-
that much.
I will
That,
say that.
yes,
That is one of the
that much,
reasons.
my lord. That will suffice.
And opportunity for cross-examination on.
If you rely on that, otherwise you discard it, don't rely on that. And see if you can sustain your.
Observation regarding and the
I'll
supply
give-
of the relied upon.
I'll give that.
Yes.
This writ petition has been filed. May Mr. Saraf please correct me on
No, no, I have
No, in
explained
this
to
case,
Khalid sir when he was
in this
there
case, in
that
this,
we
Mr.
have a
Sanyal,
better tale of
in
passing
this
the order.
case, if it was only on e-way bill, I would have not been that convinced. But he has gone on to produce transporter details, vehicle information, delivery acknowledgement. So many things are there.
That was problematic. Your lordship
E-way
mind
bill, I
that.
would have,
That's why I tried to
bypassed.
sway your lordship.
I'm telling you, your lordship, I have advised them. The Khalid, when Khalid sir was the commissioner.
এটা শেষ করে দিন। কি লিখলে? হ্যাঁ, full stop. Is there any question?
Well, there is a not today. I have not fixed it. Next week, lordship, not today now, next week. Next Wednesday.
Very well. Not today means it won't be taken up tomorrow, day after. It will come on Monday.
Next Wednesday, lordship, kindly.
Very well.
Wait, please, my lord.
Yes, Mr. Kunduli, appearing for GST.
Yes.
My lord, on the earlier instance, my lord was pleased to ask me to come up with judgments which directs restoration for cancellation.
Oh,
I'm carrying this.
give me. Only for non-filing of returns, non-filing of returns usually we pass.
If he was showing me this order, I go, this is for non-filing of return.
Legally.
There are only one thing,
Yes.
but that's it. One. And we pass that order, but
Then was a matter wherein 2A3B suppression, only a table was given in the show cause regarding the mismatch in 2A3B, and 74 was invoked. So Lordship has seen section 16 to AA, and then on that ground my learned friend was told to take him. And there is a CAN application on it.
My lord, my junior Mr. Bhonjo will address your lordship, my lord.
During the pendency of writ petition, they
Bhonjo will
passed the
address-
order, so I brought the CAN on record. Through CAN the order.
My lord, my senior requested by Mr. Bhattacharya is appearing online, so therefore I am submitting my lord. Today, my lord, we are confined our argument with regarding to the writ petition that challenge the impugned show cause notice. Now, if your lordship kindly see page number 81, that show cause notice of 9/6/2025 for the period 2008, page number 81. Yes. For the period 2018-19, 19-20, 21-22, 23-24. There are allegations that they have availed access ITC, and another thing is that there is an inadmissible ITC on the basis of the invoices that is supplied by the suppliers who are found to be non-existent. Now the thing is that the glimpse of their argument is that previously for the year 2018-19 and 19-20, show cause notices has been issued under section 73. So you cannot further proceed with that period. That amounts to a parallel proceeding. Now, second thing is that, my lord, audit commissioner at Kolkata 1 audit commissioner, they have already initiated the audit. Proceeding has been done, and there is a summons by the anti-evasion unit. So everything, there has been every proceeding from either from the anti-evasion unit or from that audit commissioner, now where the question of comes to section 74. Now the thing is that, my lord, summons issued by the anti-evasion unit, they did not turn up. What they have submitted, look, we have there is a audit going on by the audit commissionerate, so you cannot proceed, and they have relied upon judgment of Buildcon, our honorable court's judgment, my lord. And before the, my lord, anti-evasion unit, they are saying that no, you cannot proceed because audit commissionerate is proceeding. So he's playing hide and seek. Before that authority, he's saying that another authority is going on, but he is not submitting anything. Now the submission is, my lord, with regarding to the audit, when audit will commence. If your lordship kindly see section 65 subsection 4.
65.
Section 65, my lord. Section 65, if your lordship kindly come to explanation. Subsection 4, explanation.
65, yes.
Explanation, my lord. My lord, may I read, my lord?
Yes.
For the purpose of this subsection, the expression commencement of audit shall mean a date on which the records and other documents called for by the tax authorities are made available by the registered person or the actual institution of audit at the place of business, whichever is latter. So we have requested him to submit the document. He did not submit documents, taking the plea that the authority of anti-evasion unit is proceeding with the matter, so I cannot submit the documents. So therefore, my lord, in our show cause notice as paragraph number 2.16, the authority has categorically stated that due to non-submission of the documents, the audit could not be conducted. Therefore, this question of this, my lord, grounds will not applicable, my lord. Now another thing is that the summons, as your lordship, my lord, recent judgment of the Supreme Court, the summons when it is not at all initiation proceeding, the initiation or culmination of proceeding by your issuance of the show cause notice. Now when they have only issued the summons, but they did not participate. Now the question is that where is the suppression of facts? Section 74, where is the suppression of facts? Now if your lordship kindly come to show cause notice, my lord, page number 87.
57.
Paragraph number 2.18.
Yes.
Paragraph number 2.17 onwards, man. Paragraph number 2.17.
Yes.
From the discussion herein above, it is evident that the registered taxable person willfully tried to confuse both the investigating authorities of Headquarters Anti-Evasion Unit of CGST and CX Kolkata South Commissionerate and CGST and CX Audit 1 Commissionerate with clear, my lord, with clear intention to avoid the proceeding initiated against them. Further, they have failed to comply with the summons issued against them or the oral or written deposition and submission of relevant documents, and also failed to submit the document as requested by the CGST authority, CGST and CX Audit 1 Commissionerate to avoid any further investigation against the unlawful activities conducted by them. Now, if your lordship can look paragraph number 2.18. Detailed scrutiny of returns revealed that the said registered taxable person availed inadmissible ITC from multiple suppliers who have failed to file their monthly statutory returns in the form GSTR 3B or whose registration was cancelled with retrospective effect as the supplier was found to be non-existent at their declared place of business. The details of the supplies and inadmissible ITC availed on the strength of invoices issued by the registered taxable person as tabulated below. Now, if your lordship kindly come to, this is the tabulated form has been given. Now 2.19. Further, registration detail of the supplier mentioned in 2.18 of the notice was verified. It was revealed that the reason for cancellation of registration is as follows. Now, what is the reasons, my lord? That has been stated in the last column, my lord. Non-filing of the returns for the consecutive period of 6 months in violation of provisions or violation of provision laid under section 29(2)(c) of the CGST. Each and every day 29(2)(c), that is the registration obtained by means of fraud and suppression of facts. Now their registration has been cancelled. Now, if your lordship kindly see paragraph number 2.20. From the above table, para 2.18 and 2.19, the following things comes to notice. The said registered taxable availed and utilized ITC to the tune of rupees such and such on the strength of invoice issued by Aster Trading. However, as per the entity, Aster Trading Company has not filed their monthly returns in the form of GST 3B. Such ITC is admissible ineligible for availment as tax collected has not been deposited to the government exchequer. This is a violation of section 16(2)(c). That is stated, if you collect that, you have to deposit to the government exchequer. Unless a government exchequer that gets that amount, then how can I, my lord, I can give the ITC, my lord. Now, the said registered taxable person knowing fully well availed and utilized the ITC on by Aster Trading in violation of.
Please call Mr. Saraf if you can. Anytime in the day.
Lordships.
In violation of provisions of section 16(2)(c) of the CGST, that inadmissible ITC should availed and utilized by the taxpayer to be demandable and recoverable from the taxpayer. Now, if your lordship kindly see from serial number A to I, there are, my lord, we have Sokoj Notice Issuing Authority has specifically mentioned that they have not filed, the supplier has not filed their GST 3B returns and that tax has not actually deposited with the government and the suppliers found to be non-existent. Now, if your lordship kindly see paragraph number 2.21, page number 92. Further, from statement generated system generated comparison sheet as available in the GSTN portal, it appears that the said registered taxable person availed access ITC in comparison to ITC available for availment as per GSTN 2A of the taxpayer. From the comparison sheet, the access availment of ITC as notice is tabulated below. Now, it has been tabulated. What is the access availment of ITC? Now, my lord, kindly come to page number 93, para 3.0. Why the reason for invocation of the extended period of limitation, my lord? As per section 16 of the said act, the recipient taxpayer is not entitled to avail input tax credit unless they have a valid tax invoice or debit notes or such other tax documents issued by a person or entity registered under the said act, or in case of availability of proper tax document, input tax so charged on the supply of goods or services of both by their supplier has been paid to the government exchequer by the supplier. Now, as per section 38 of the said act, every recipient of supply receives an auto-generated electronic statement showing all the supplies of goods and services received by him from the registered suppliers, and accordingly he can avail the input tax credit on such supply as per the provision of section 16 of the said act. Presently, the auto-generated electronic statement is received in the pro forma GSTR 2A / GSTR 2B. Thus, availment of ITC in excess of the figures shown in the GSTR 2A and 2B are irregular, as the said taxpayer has been provided as the said taxpayer has been provided by the GSTR 2A 2B electronically, and the said taxpayer was well informed with quantum of ITC rightfully available to him, but with the malafide intent to evade the tax, the taxpayer has availed ITC in the GSTR 3B in excess of the available ITC in GSTR 2A / 2B and suppress such facts while filing statutory returns. Now, we have lordship kindly come paragraph 3.3. Further, regarding availment of inadmissible / ineligible ITC, credit availed and utilized on the invoices issued by multiple suppliers who were either found non-existent during investigation carried out by GST officers or failed to file monthly statutory returns in the form of GST 3B as discussed in para 2.18 to 2.20 of this notice, what I have referred earlier, my lord. The taxpayer, even after repeated reminders, failed to provide any evidentiary documents to support the validity of the ITC, so availed on the strength of invoices issued by the supplier mentioned in para 2.18. It appears that the said registered taxable person, being fully aware of inadmissible of such ITC, has availed and utilized such ITC while discharging tax liability on outward supplies. Now, 3.4, my lord. Further, as per section 155 of the said act, the burden of proving the eligibility of availing input tax credit lies on the recipient taxpayer. Accordingly, the burden of establishing that the supplies received by the taxpayer has already been taxed at the hand of the said supplier, and accordingly the tax has been paid in government exchequer, lies upon the recipient taxpayer who availed on such supplies. If the same cannot be established by the recipient of taxpayer, they are not entitled to take credit for input tax charged on the supply by the supplier as per section 16(2)(c) of the said acts. Now, if your lordship kindly see 3.5. Being a registered taxpayer, Card Infra Limited is well versed with the GST laws and provision of taxation. They should have taken reasonable steps to ensure genuineness and admissibility of ITC being availed and utilized by them. As stated above, the burden lies on the registered taxable person to demonstrate that they had taken such care. However, it was observed that the registered taxable person, having full knowledge, availed rupees 88 lakhs 57,040, whose admissibility has been discussed in para 2.418 to 2.20 of the notice, as the ITC of rupees 80 lakhs 57,040 holds no legal sanctity and the tax has not actually been paid to the government on such transaction. Therefore, the such ITC was ineligible for availment as per the provisions of section 16(2) of the CGST Act as well as corresponding of WGST Act. Read with section 36 of the said rule, but the said registered taxable person deliberately availed of such inadmissible ITC with sole intention to evade payment of tax. Now, 3.6, my lord. Further, as discussed para 2.21 of this notice, excess irregular ITC availed to the tune of rupees 1,48,84,011 without any proper tax invoice or debit notes or other such tax documents in violation of the provisions of section 16(2)(a) of the said act clearly shows intent to evade payment of tax. The proprietor of the said RTP during investigation failed to provide valid documents in relation to ITC availed by them and failed to appear when summons were issued. Even if the said registered taxable person would have succeeded in producing valid tax invoices, however, non-reflection of the said invoices in the GST 2A of the recipients implied that the tax charged in those invoices or have not been paid to the government exchequer, thus ineligible for availment under the provisions of section 16(2)(c) of the said Act. However, the registered taxable person having full knowledge of the same availed and utilized ITC in excess of the rupees one crore 48 lakhs 84,011 with clear intent to evade payment of tax so collected and to defraud the government exchequer. Now, my lord, had the department officer not initiated the now the thing is that your lordship kindly come to definition of suppression, section 74, my lord. What is suppression? Explanation 2. Suppression shall mean non-declaration of facts or information with a which a taxable person is required to declare in the return, comma, statement or report or any other document furnished under this act or the rules made thereunder, or failure to furnish any information on being asked for in writing by the proper officer. Now, my lord, he has been asked repeatedly by the department to produce the document to prove your legality or sanctity of the availment of the input tax credit, but he failed to produce, my lord. Even in the case of the before the audit authority or before the authority anticipation who issued the summons. Now, my lord, each and every, my lord, paragraph of the show cause notice, the department, it is the category case of the categorically when it stated that there is a intent to evade the payment of tax, there is a suppression. So in that elements of section 74 is very much present in the show cause notice. Now, my lord, I am placing one decision, my lord, Punjab and Haryana judgment, my lord. If your lordship kindly see, my lord. Didi, এটা একটু দেবেন? Here, my learned friend argued that when section 73 proceeding has been issued and completed, we cannot initiate a section 74.
I have not argued.
My lord, we have stated that already department issued the show cause notice, 2 show cause notices. Last occasion, my lord, he has submitted.
No,
Now,
I
if your
never argued
lordship,
like that, lordship.
maybe I am wrong, but if your lordship kindly see paragraph number 5, my lord. We have carefully considered his submission and find that the contention raised by the petitioner are wholly misconceived. Issuance of notice under section 73 of the Act or dropping of the same would not prevent the authorities from independently initiating proceeding under section 74 of the Act. The said proposition has also been accepted by the Allahabad High Court in HCL Infotech Limited, on which my learned friend also referred in this writ petition, my lord. So far as the question raised by the petitioner with regard to parallel proceeding, that is also the case of the petitioner being conducted by the DGGI and the Haryana State GST Intelligence Unit as well as the Assistant Commissioner CGST concerned. We find that while the Assistant Commissioner CGST issued a letter on dated 10th March 2023 to the petitioner requesting him to deposit the tax liability, the office of the DGJ only issued the notice seeking certain queries. However, none of the authorities, either the CGST or the DGJ, has proceeded or initiated proceeding under section 74 of the Act. We find that the notice under section 74 of the Act has only issued to the petitioner by the Haryana State provide its impugn notice dated such and such along with summary of show cause notice. The grounds have been detailed in the such and such. Now, my lord, kindly see paragraph number 8. From the above, it apparent that allegation against the petitioner are that. Now, my lord, I am referring 7, what is quoted in the, my lord, judgment. On review GSTR 9 and GSTR 2A, it has been noticed that the taxpayer has availed excess ITC to the tune of rupees 8 crores such and such under the head IGST and 23 crores in CGST and such amount SGST in 3B on being compared to ITC appearing in GSTR 2A. So there is a difference of GSTR 2A and 3B. Same is evident from the table D of GSTR 9. Since the vendor has not declared his tax liability in GSTR 1 due to his ITC is not appearing GSTR 2, therefore, this creates an impression that the vendor of taxpayer has not deposited tax liability in government treasury. Due to this reason, the recipient, that is taxpayer, has not fulfilled the condition section 16(2)(c). This is our case, my lord. They have not fulfilled the condition of section 16(2)(c). You are hereby so called justify such and such. Now, from the discussion, my lord, it is apparent that the allegation against the petitioner are that which he is stated in having availed access to the tune of rupees such and such under SGST. However, the same is not appearing in 2A, which reflects that the taxpayer has not deposited the tax liability in the government treasury and has availed the same wrongfully. Now, my lord, yes. Now, this is only at the stage of show cause. Now, I am not looking at the adjudicating authority. I am only confining my argument to the show cause notice. This is only at the stage of show cause notice. Now he has that liberty, or could have had the liberty, though he has participated to give his defense, to make his submission. So where is that jurisdictional error, my lord? The question to challenge the show cause notice. Only thing is that 74, invocation of section 74. But detailed reason has been given, elaborate reason has been given by the authority while issuing the show cause notice, why section 74 has been invoked. So when there is an alternative forum is there to provide his defense, so this writ petition is not at all maintainable, my lord.
My lord, may I, in addition to Mr. Bhanjo, my lord, may I add 2 points, my lord. In fact, my lord, my learned friend, Mr. Kanodia, intend to say that time limit for issuance so-called notice under 73 has been elapsed. That's why the department resorted the issuing so-called notice under section 74, and there is no fraud suppression. That is the all throughout the writ petition he, my lord, pleaded. My lord, in the so-called notice, you will also find they categorically stated that my lord, suppression has been made. And it has been detected. Had that been the no notice or investigation, my lord, it will not come to the light of the day. Therefore, my lord, issuance of so-called notice is proper. My lord, there is no violation of principles of natural justice, my lord. He could have, my lord, participated in the adjudication, and my lord, at this stage the order has been passed. And after that, he filed the CAN application without, my lord, whispering a single word. Why the my lord, order is nullity, or why the order will not be sustained. Therefore, my lord, what Mr. Bhanjo is saying, my lord, this writ petition at the threshold, I don't think, my lord, writ code will entertain, because there is no violation, my lord. If he is really agreed by the original, my lord, he could have come with the proper grounds, or he could have preferred the appeal. All questions can be decided by the appellate authority, my lord. And what is the question, my learned friend says, or it is felt from your lordship, that if that has not been stated in the so-called notice, how he can give the reply? Question is that my so-called notice is elaborately described, my lord, everything. Every chance has been given to the assessee, my lord. He could have done by giving a proper reply. If he failed to do so, then my lord, he will not entitled to get relief, my lord. If a litigant is not vigilant, my lord, he is not entitled to get the relief, my lord. That is the set principle of law, my lord. And in any event, my lord, whatever is any allegation, my lord, he could have preferred appeal then, my lord.
Worships. The proceedings initiated by Anti-Evasion was way back on 3rd of March 2022. First letter, no summons. I replied to that letter in June 22. Worships, my learned friend has shown you that table at page 87. Kindly come to that page 87. In fact, I had not argued on this table. I had only argued on 2A, 3B. Now, when I'm invited to argue on this also, I'll first place this. 87, Messrs. Esther Trading, Lordships. Now, Lordship, kindly comes to page 59. Initiation of proceedings. 59, annexure P1. This was the first letter which I got. Page 59, my lords, is there. 59A is the typed copy, lords. That is much legible. 59A. 59. In my copy, it is 59A also. Typed copy is not with. I appeal. That it says availment of irregular ITC by Messrs. This. During the investigation initiated against your company, it has been observed that you have availed ITC to the tune of rupees this, barged by Messrs. Esther Trading having GSTN. On the verification of status of Messrs. Esther Trading, in the portal it is seen their registration has been cancelled as they have filed GSTR 3B for January 18 and February 18, but not filed 3B for the subsequent period. This was the first letter. What I replied, Lordship, page 60 is my reply. And this letter is dated 22, Lordship. Kindly takes the date into picture. March 22. I reply, with reference to the above, it may please be noted that we have not received any input from the company that you have mentioned, Mr. Esther Trading. We have no business transactions. Because I have not taken any ITC, I stated I have not taken. This is the first reply, way back in 22. Next, Lordships, they issue me summons. At page 61. Now they mention 3 more parties in that summons. Now this is also 20, this is 23. After 1 year of that, first letter, then 1 year they stopped. Fine. After 1 year, they again issue me a summons. Now I give a reply to it at page 63. In 23, I reply to them. And I give my all my justifications. And as per me, there was some short payment of 2 lakh rupees. I paid that. That DRC I also attached. 23 also over. Now, June 23, they again give me a notice at page 65. Lordship may take 3 parties, Esther, B.S. Krishna. In the page 87, my learned friend has referred these 3 parties, first 3 parties are this only. So since 22, these 3 parties, they are giving me notices. I am replying. It is not the case I have not replied. Every reply is on record. 3 years down the line, they sit up and suddenly they wake up and say, you have suppressed this fact. If this can be suppression, then anything on earth will always be a suppression, Lordships. My replies to page 65 is at page 66. 67, I gave a detailed reply. Kindly take Lordship page 67. For each of the suppliers, I have given a reply.
Where is the violation of principle of natural
I
justice?
did not interpret it when they argued, Lordship. Kindly, my senior may not interrupt me. I never interrupted them. Page 69, 7 is my detailed reply with all documentary evidence. Then page 69 is my further reply. For each of the suppliers to whom, for which they had issued me notice since 22. And replies are on record. Now, Lordships, suddenly they issue me a last summons. They issue me the show cause directly on 11 June 25. I am only with the anti-evasion, Lordship. I had not argued in the whether audit proceedings is correct or not, or whether to show cause under 73. I had not placed my case on those facts. I was on the facts for these suppliers, and then Lordship may kindly now take Lordship to 92. What I had argued on the last day is page 92 only. Up to page 91 is their case that these dealers have not filed 3B and you have availed ITC. Where is my reference to the replies since 22 that out of these dealers, page 92, 66, Lordship, that I referred to them that under section 73 for my entire ITC for section 16.4, which I had referred to before the Lords on the last day, Lordship, 16.4 had a time period to avail ITC. If I don't avail, then my entire ITC was disallowed. So they had issued me a show cause for that. That for 1819 and 1920, because you have filed your returns belatedly, you will not get any ITC. Then the amnesty scheme came. We replied to that, and all those were dropped. So they had issued me already a show cause for these 2 years on the ground of ITC. Now, ITC 1, once they are taking the entire ambit of ITC under picture, if that gets dropped, suddenly they invoke suppression for, okay, this out of this ITC, this much is RC cancelled party. They cannot pick and choose as per their convenience, because department, the central government brought in 16.5 to allow the ITC to be availed up to 5 if you have filed a return up to November 21. I came into that picture because it was an amnesty scheme by the government. So they dropped the proceedings. Now, Lordship, even this proceeding, the anti-evasion started the proceeding in 22 March. All my replies are on record. To that, what extent they have stated. In fact, for 2A, 3B, which is the major demand in my case, there was never a document sought for in neither of the summons, neither of the letters. Suddenly, in page 92, kindly take slots. Page 92, 2.21. They give a table. SSC, this is the table wherein, as per this table, it is seen you have availed excess ITC. And what do they say to invoke suppression is at page 93, para 3.2. That it is auto-generated. It is auto-generated. It was with them. It was with me. I had filed 3B. It is not an allegation. I had not filed 3B. 2A was seen to them. 2A was seen to me. And that is what, Lordship, I was referring on the last occasion, the judgment of Bharti Airtel, wherein Supreme Court has stated that 2A is only a tool. You have to take ITC under section 59 on self-assessment basis. Kindly take, Lordship, page para 46 of this judgment. Para 46, Lordships, Supreme Court gives certain observations. We need not multiply the, my Lordships, Para 46, Lordships. We need not multiply the authorities referred to in the concerned judgment and cited before us. And it's in our opinion, these decisions have not been dealt with the cardinal aspect of statutory obligation fastened upon the registered person to maintain books of accounts and record within the meaning of Chapter 7 of 2017 rules, which are primary documents and source material on the basis of self-assessment is done by the registered person, including about his eligibility and entitled to get ITC and of output tax liability. OTL means output tax liability. Form 2A is only a facilitator for taking an informed decision while doing such assessment, self-assessment. Non-performance, non-approvability of Form 2A or for that matter other forms will be of no avail because dispensation stipulated at the relevant time oblige registered person to submit returns on self-assessment, which is section 59. Now, Lordships, that is why what I pointed on the last occasion, the government brought in section 16(2)AA with effect from 1st January 22. Up to 1st January 22, 2A was a tool. I cannot edit it. It is just a feature to me. I can see it, but I have to take credit as per self-assessment. And they introduced Rule 36(4) from August 2019, wherein they accepted this principle. Yes, because it's a new regime, many suppliers are not uploading correctly. So, okay, if your 2A is 100 rupees, I will allow you to take 120. Rule 36(4). From August 19 till December 19, it was 120%. From January 20 to December 20, it was reduced to 10%. And then from January 21 to December 21, it was reduced to 5%. And from 1st January 22, it was abolished because 16(2)AA was introduced, wherein government state mandated that only those ITC can be availed which will come in 2B, and the concept of 2A was done away with. Now, in the entire show cause, they give me a table. And they give these figures and say you have suppressed. Had this anti-evasion not come, this would have remained unearned. What would remain unearned, Lordships, if I ask this to myself? 2A is an auto-generated statement they accept. 3B is filed by me on self-assessment. Prior to this date, not a single communication with me asking for 2A, 3B difference. Not a single communication. Suddenly on the last day, they wake up because the suppressed, because time period is expiring. 18-19 normal period expired in 2021. COVID extension came. It was extended up to 23. They started this investigation in 22. Even have they taken the benefit of COVID-19 extension, they had time till December 23 to issue me show cause notice for 18-19 and up to June 24 for 19-20. Lordship sees their conduct. They start an investigation in 22. That thing, every time they ask for document, we submit on record. Suddenly, on the verge of 18-19 becoming time barred, they issue me a show cause. And just this table in the show cause. They say everything is auto-generated, you have suppressed. If auto-generation can be suppression, where they have sought this document from me? Any time, any place, in any summons, any letter, no. Now regards to audit, what my learned friend had argued, I had not argued. In the meantime, when this proceeding was continuing, audit notice came. I wrote to the audit and I submitted documents. Lordship, kindly takes page 73, my submission to audit. What did I wrote? And I submitted 2 years document to them. Page 73 is my reply to the audit notice, Lordship, again in 23. In this regard, the auditee state proceeding under 61 for 18-19, 19-20 has been concluded and a show cause notice has been issued. It is regularly submitting document required by the above authority. I have attached the show cause copies. Next page, page 74. Further, I refer to summons issued by anti-evasion. 2 summons was issued to me. The auditee then, I refer to the judgment of RP Buildcom. Then, Lordships, the auditee therefore, on the facts and judicial pronouncement, requests a good sir to confine the audit from 17-18 and April 20 to March 22. I say, I will submit this. And what I have submitted, Last these 3 years, I have submitted the documents to audit. Suddenly in the show cause, they say you have not submitted documents to audit. Blatant lie in the show cause. Kindly see the receipt, page 73, is their acknowledgement by the audit department. 3 years document submitted to them. And what are the document, lordships? 1, 3B annual report, 26 years director report, everything. And audit says that no, this person has not submitted. Anti-evasion takes that as a ground to invoke suppression against me. The audit could have written to me, no, I will not allow you. Why you are, I will not take your submission that this period is covered by that. You have to submit. No correspondence by audit ever. And what was anti-evasion doing since 22, lordships? March 22. And in the show cause, the first 3 parties which my learned friend has shown, page 87, I had clearly mentioned I have not availed this ITC. No record of that. I have stated I have not availed ITC. Still you say no, you have to reverse because he has issued you invoice. Because in GSTR 1 of his, my name is coming. That does not mean I have availed ITC. I have availed ITC under 59, which is self-assessment. Now, under all these proceeding, lordship, they issue suppression. June 25, 11 June, last day to issue show cause was 30th June. 11 June, they issue a bunch show cause for 5 years. 18, 19, 19, 20, 20, 21, 21, 22, 22, 23, in fact, 6 years in this case, 23, 24. Invoking suppression, saying that, okay, this portal data was with you, but because we have come now, so it is suppression. But what is 16.2C? 16.2C says, subject to provisions of 41, tax should be paid by the supplier. There is no allegation in the entire show cause that I have not paid tax to the supplier. Now, 76, section 76 is the section, lordships may kindly take once, wherein 76 says, first recovery is to be done by the department from the supplier. And if supplier cannot be found, then certain actions. But where is that record that they have initiated an action against supplier? Nothing on record, just vague inquiries. Lordships have passed such orders wherein 6 months registration cancelled persons are coming before your lords, and lords are restoring it subject to the conditions. In all these cases, it is a case of 6 months. So whether they have restored it further or not, nothing, they have kept quiet. So where is the case of suppression? They have not placed anything on suppression. Lordship, I have attached certain judgments on the ground of suppression. Lordship, may kindly take those judgments. Lordship, first is the board instruction at page 173. CBIC has come up with a detailed instruction as to which cases should be a case of suppression. Page 173. May I place this, Lordship? Instruction number 5 of 23-GST. Judgment of Honorable Supreme Court in case of Northern Operating System. Attention is invited to the Honorable Supreme Court judgment dated this, in civil appeal dated this, on the issue of secondment of employees by overseas entities to Indian firms and its service tax implications. Representation have been received in the board that subsequent to the aforesaid judgment, many field formation have initiated proceedings for alleged evasion of GST on the issue of secondment under section 74 of the Act. The matter has been examined by the board. It appears that the Honorable Supreme Court in its judgment inter alia took note of various facts like agreement between NOS and overseas group companies and held that secondment of employees by overseas group companies to NS for the taxable service of manpower supply and service tax was applicable. It is noted that secondment as a practice is not restricted to service tax and the issue of taxability on secondment shall arise in GST also. Then lordship, they give the certain judgments. Lordship kindly takes para 3.1. It has also been represented by the industry that in many cases involving secondment, field formations are mechanically invoking extended period. In this regard, 74 reads as follows. From the perusal of the word 74, it is evident 74 can be invoked only in cases where there is a fraud, willful misstatement or suppression or therefore only in cases where the investigation indicates there is a material evidence of fraud or willful misstatement or suppression to evade tax on the part of taxpayer, provision of 71 may be invoked for issuance of show cause, and such evidence should be a part of show cause. The above aspect may be kept in consideration while investigating such cases and issuing such show cause notices. This was a specific instruction by board for because of one issue, but they came up with the instruction for GST that okay, 74 you cannot invoke mechanically. Please be very sure. Now let's see the next. Let's see page 263, Supreme Court in cosmic dye chemical. Para 5 onwards, may I please? The main limit of it was related to section 11A of Central Excise Perimetry to 74. The main limit of section 11A provides limitation of 6 months. In cases where the duty is not levied or paid or short levied or short paid or initially refunded, it can be recovered by the appropriate officer within 6 months from the relevant date. But the said period of 6 months gets extended to 5 years where such non-levy, short levy is by reason of fraud, collusion or any willful misstatement or suppression of facts with the intent to evade duty. Now, so far as fraud and collusion are concerned, it is evident that the requisite intent, that is intent to evade duty, is built into these words. So far as misstatement or suppression are concerned, they are clearly qualified by the word willful, preceding the words misstatement or suppression of fact, which means with intent to duty. The next set of words, contravention of any provision of the act or rules, are again qualified by immediately following words with intent to evade duty. It is therefore not correct to say that there can be a suppression or misstatement which is not willful and yet constitutes a permissible ground for the purpose of provision to 11A. Misstatement or suppression must be willful. Now coming to the fact, the appellant says that he thought bona fide that he did not include the value of this in his declaration for the reason that the product was fully exempt from duty and the notification dated this. Certain facts are brought to our notice in the plea. It is also brought to our notice that on the date of filing his declaration, 2 high courts had taken a view that the goods exempted from duty are not includable. The appellant factories in the state of Maharashtra and Bombay High Court has not taken a view on one way or the other. In the above circumstances and because of the fact received at misstatement in the declaration by the appellant or suppression of the facts therein as the case may cannot be fulfilled, the appeal is allowed. So the Supreme Court interpreted that every misstatement or something, it has to be first proved to be willful. Plain when you are writing in the show cause in every para, this is done with intent to duty, with intent to evade duty, cannot lead to a suppression. Next, Lordships. Page 287, Honorable Division Bench of the Allahabad High Court, Lordships, in Bharat Mint, 287. This is GST. Next place, Lordship, 287. Lordship, may kindly come to Lordship. There are 3 submissions have been made that a notice issued under 74 is without reason and deserves to be questioned set aside inasmuch as none of the ingredients as required for issuance of notice under 74 are neither present nor have been alleged in the notice and therefore the notice is there. Para 5, 288. When sending counsel contested the submission, it was indicated that it is not necessary to make allegation in the notice under 74 of the Act by using the language of 74. The facts themselves speak for the ingredients and therefore the plea raised in this regard has no substance. Now, then they have extracted. Then they have para 8. This court, in the case of Vedilal Enterprise, wherein the same officer in adequate had adopted the similar method while deciding the notice under 73, finding paucity of time, left the issues undecided and issued notice under 74. Came to the following: a bare perusal of the language indicated that a reference to notice under 73 has been made and the explanation filed could not be verified and therefore further explanation was expected. The very fact that the respondent has sought further explanation and not a word has been indicated that the petitioner intentionally committed fraud has given willful misstatement or suppressed, which are ingredients based on provision of 74 of the Act, can be invoked necessarily shows lack of requisite ingredients. In view of the facts, so this was the case wherein no ingredient was present for 74. Next, Lordship, Vadilal is again there, but Vadilal I am keeping Lordship. Then page 295, Telangana High Court on separation. Page 295. I came before Lordship against Opus only challenging the separation. During the pendency in my CAN application, I have written that we have written to the department that the matter is pending, but they are proceeding. Page 299, again there is Allahabad High Court. Lot many high courts have now decided on the point of suppression elections. That whether 74 can be mechanically invoked. Page 303, our division bench in similar matter where 2A, 3B was involved, has given a stay of the proceeding. The learned single bench had dismissed it and the division bench had given a stay at page 303. In page 303. Lordship. It was dismissed on the ground of statutory alternate remedy. SCL Infotech, which my friend was also learned friend was explaining, that is a classical judgment wherein 73 once done on the same self of facts. Then again you cannot invoke 74 because you cannot say suppression. In my case, they had issued 2 years only. 73 is entire ITC disallowed. But because of the amendment in the statute, that was allowed. Now they pick certain ITC out of that and they say you have suppressed. And page 321, Lordships, it is a interim order of the Honorable Delhi High Court regarding mismatch, wherein suppression was involved. Page 323 is the Honorable Single Bench of Guwahati High Court, Lordship, wherein interim protection has been given on grounds of, and page 323 is show cause, at show cause stage. But these are interim, Lordship. You may not have any binding effect. Then Lordship, 325 is one of the latest judgment of the Honorable Odisha High Court Division Bench, wherein on the similar points, the ITC related 74 was invoked. The bench has indulged and stayed the proceedings, stating there is no ground of 2A, 3B, 74 you cannot invoke. So my submission before your lords is for the 2A, 3B demand. Lordship, in the applications. Lordship.
Yes, my lord, they filed their reply, my lord.
Lordship, this is my application, Lordship, can one.
Yes,
Lordship, kindly take the application. Lordship, para 3. Your petitioner state that on 11/9/25 it had filed an adjournment letter dated 9/9 against the personal hearing scheduled on 12/9, stating that the impeached show cause under before this Honorable High Court. Your para 4, your petitioner state that though the impeached notice is the subject matter of challenge, your petitioner, in order to comply with the statutory requirement of filing, had filed a detailed reply in DRC 6 dated 10/11 against the said show cause. Then Lordship, para 5, your petitioner stated that during pendency of the writ petition, the respondent proceeded to pass the impugned order. And now kindly takes the impugned order, Lordship, starts at page 10. Now what they have dealt with, Lordship, discussion and finding starts at page 45. Page 45, discussion and finding. Till then it is my reply to show. Extracts of that. Para 4.2, I find although the writ petition application filed is pending before the Honorable High Court, Kolkata, no stay of proceeding has been granted by the High Court, therefore I take up for this. So he writes because there is no stay, in fact there was no order of admission also or without any stay, so he had proceeded for adjudication. Now this is how he deals with suppression. Page 56. In fact, the ground of bunching was also taken. At page 55, he has dealt with the issue of bunching. And page 56, issue of invoking extended period. In the instant case, the responsibility of the said noticee to voluntarily disclose relevant information in appropriate manner is much greater in self-assessment regime. In this connection, evaluation of tax behavior of the said noticee reveals that the intent to avail ITC regularly to the tune by an act of suppression, inasmuch the taxpayer availed and utilized ITC of rupees by declaring it as eligible ITC in return, knowing it fully well that the ITC on the imputed supplies was not eligible to be availed, such misdeclaration by resorting to suppression. Now, the law allows me to take ITC more than what is in 2A. How can it be suppression? The law says 2A is self-assessment. Rule 36(4) acknowledges that and says, yes, you can take ITC up to this figure. In fact, in my reply, I had given them a table. This is within the tolerable limit. In my reply, I had submitted that this is the rule. 100 rupees is this. 20% I can take subject to formula. I have taken within this limit. Still, they say it is a suppression. Because I have taken credit, it is a suppression. And last para, in the instant case, the said notice was registered and was well aware of the laws and regulations. So I find it was a deliberate withholding of essential information from the department, and all the material information discussed they had concealed from the department deliberately for the purpose to avail illegal items. This is their only confirmation of demand and acceptance. And bunching, Lordship, I am the last occasion I had asked Lordship, had not granted me that liberty to file supplementary affidavit, but this bunching point was taken in the show cause reply also. So these are certain judgments on that. Regarding the application, Lordship, your Lordship, one order in this that Kirti Devra case, that when can an application can be construed to be a proper, which I mentioned in the morning. Lordship will pass a detailed order on this. Lordship had indicated. Here in this case, that letter of the bank was not there. But your Lordship says in para number 6, can 1 is therefore treated as a part of the writ petition instead of directing the petitioner to amend it for reasons recorded.
Will give short reply, madam.
But now kindly stay till that time, because last day it was submitted that matter is returnable. I had not fresh, but now Lordship is till the returnable date. I am not
There
because
to make out the prima facie case, my lord, then your Lordship.
There is no, with due respect of submitting, my lord, my learned friend could not make out any plausible grounds for interference, for calling for interference by this court. My lord, whatever my learned friend is harping, my lord, if your lordship, my lord, I can't hear your lordship, my lord. I do not know whether it is.
কোথায় গেল আমার Can it be taken about 18? My lord, can it be taken on 18th, man? Seventeenth. Problem is that there is a clash of division and our revenue group for matter is on Tuesday and Thursday, man. This is the whole problem. Let's see Monday.
15th. I hope if whatever your Lordship
Grateful, my lord.
Lordship, 16th, Lordship. I apologize. I may be at Vijayawada. 17th, Lordship. 17th. 17th.
Let it be there, my lord, but I don't know whether we'll be able to appear
Not,
before.
otherwise, we'll take one day, not today only. 17th.
Achha.
Lordship, will
Next.
Lordship, get. Lordship, do I need to file any written notes? Not. Lordship.
One round.
Get. Get.
Section 155.
Great. 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 Good.
12:13, Mr. Chakraborty will be doing the matter. I will specifically. No, he'll be there. Today he has some personal difficulty. Monday he'll be there. Today he has some personal difficulty. He is not there. Court itself. Not today. Third. My learned friend is appearing in 12, 13, and 14. These three matters are. Yeah.
My lord, will it be taken up on Monday? Can it be taken up Monday, my lords?
Monday. Monday will be there.
Oblige.
If yes.
15 is Lordship, that yesterday's matter. That pre-show was, yes, the pre-show cause date is prior to that. And Lordship, in Ramkumar Sinal, in fact, the show cause was of May. So that is why what I submitted, the proceeding started from prior to that date. And in fact, Ramkumar Sinal, Lordship, I handed over the judgment yesterday. In that, the show cause is of May 2024, where the division bench has interjected.
If my learned friend completes his submission, then I have to something to say, Your Lordship.
No, my only point was, Lordship, first, because your Lordship had indicated, because we will go by that. Therefore, otherwise, I was arguing on 169. Your Lordship had returned all those judgments to me. So I kept.
Additional notices and this thing, his show cause is dated 2/5/2024. It's an admitted position from January. The portal was renewed. The portal renewed. He's not admitting that.
I am saying.
Then also in second 2/5/2026.
That is what.
Lordship 2026, because this is the portal. I have got the.
ये तो अभी वाला है
अभी वाला नहीं, अभी तो हट गया है। एडिशनल नोटिस में ये सब मिल चुका है।
ये पाँच पहले के हुआ, ये जो खर्च पास हुआ, ये
my instruction, sir, this is the, because in another matter which my learned friend is saying, because since it pertains to 2026, so
no,
that matters.
Yes, I indicated.
I was waiting for this. I was waiting for this.
Yes,
Your Lordship.
this screenshot which I had given yesterday.
This is the whole portal. How? Because this is the GST tutorial on notices and demand. So this is the first page. If someone opens it, this is the first page which comes. If your Lordship kindly sees, there's a note. In notes.
No,
because
I will place, Lordship. I will clarify.
Because your Lordship, if it comes into this thing in notes, it is the pathway is very clearly given. Because what was there before, this note was missing. As per my instruction, this note was missing because this pathway was not there. So there was a confusion. If someone goes into notices and order, they won't know what is there in the notices and order or additional notices. This pathway after 2024, this pathway was there. Notice, order, intimation, everything was written in the note. Which all notices will go to which tab? Like following notices and order of tax authorities as per my, because I am not the authority, my officers are saying 2024, this overhaul which happened, this is the format which came. But GSTIN will be the appropriate party to say that when did this overhaul happen and what is exactly the position. Other court I was not able to say.
Lordship, 16th of January. Now, Lordship,
16th of January.
even if I take this, then also the screenshot in my case, what I had given, that this was not uploaded under notices and orders. It was under additional notices. Lordship,
ये notice होता है notices
and so for additional notices, this tab has to be clicked upon.
The pathway is given. Because the problem with my officers is that they are not able to open up RTPs. What is the RTP's position? Because officers portal is different.
This will come.
In the note portion, additional notice may notice order modules advance duty, assessment, adjudication, procedure, and enforcement notices. It will appear.
But Lordship, from when this is done? So
Yeah.
It's 16th of January. In my case, Lordship, it was DRC 1A issued on 8th of January. DRC 1A, which is
pre-show cause notice. Show cause notice?
Show cause notice issued on 2nd of May.
Show cause notice.
But Lordship, under the same, Lordship, it is under the same portal. Lordship, this screenshot kindly refers. Lordship, I will not have the objective to open the portal only. I am stating that because Lordships, in my case, it's an ex parte total assessment. I'm a 65-year-old person. I am dependent upon local consultants. So I was filing, and I am a works contractor of department of the PWD department. So during this, all the tenure, all my notices and orders, which was uploaded in the additional notices and tab, went unnoticed. In fact, last year I was indicating that serial 798, that is for, this is for 1920, that is for 1890. There the show cause and everything is if 23.
But in
now, so the entire plea.
But in that case also the appellate authority, because since my learned friend is referring, I went and checked that in specifically the appellate authority says that about this note. It has, but since the matter is not placed before your lordship, I won't be arguing. I won't be referring to that.
So
matter.
This date, unless
note, so GSTIN has to be made a party.
Lordship, I am saying regarding our division bench order in Ramkumar Sinhal, kindly take that.
Because GSTIN is the party. Because
in Ramkumar Sinhal,
single GSTIN has not been made a party. In Ramkumar Singhal also GSTIN.
Lordship, let them come up with a date.
We cannot come up with the date, your lordship. We are not the authority. GSTIN has to place it.
But Lordship, there is no sacrosanct any data or any screenshot or anything. Like now the overall, therefore we have taken a screenshot. It is coming from 6th of February.
We cannot trust his Delhi High Court after Delhi High Court. I've got the Delhi High Court judgment also. I gave it to your lordship also. That is the date we can, because our officers are very incapable to, because they are only handling the officers.
In that case, then we'll argue on that 169 point also. Because then whether that uploading in the portal can be a communication or not.
That my learned friend is free to do.
Then lordship may kindly keep for that. Otherwise, I had only prayed for a remand because these are small SSC lordship.
This is my,
because in this case, lordship, 1A is prior to that also. And that is the initiation of the adjudication case. That screenshot is evident, lordships. At least on that ground, lordships may kindly see to that. Delay, as per us, it was 9 days. But as per the appellate authority, it is 210 days.
9 days he is saying because of his.
Lordship. Lordship, don't pass a sacrosanct order. Case specific lordships can take, because some SSCs you can get that benefit. Lordship, that is much obliged. Lordship,
Because then,
Lordship,
if someone
that is all, Lordship. That was why, as
I
a
was
prayer, I am
thinking-
submitting
I
before
was
your
thinking
Lordship.
to get this thing before your lordship, because the officers, my officers are saying that they can get only what the officers are saying. What the RTP is saying, they are not able to see.
Lordship, Lordship, because these cases, Lordship, which can be remanded, some taxpayers can get something.
Lordship, slight difficulty.
Lordship, my one
Because I was taking instruction with Mr. Chakravarti, because then no, 1818 is fine, your lordship.
Lordship, just one request, Lordship. The same SSC serial 798 is for 1890. I had placed both. Lordship, get
Your Lordship, I humbly apologize for mentioning at this juncture, Your Lordship. Your Lordship, item number 884 is coming under the heading of application. Your Lordship will recall in the last Friday, this is a cooperative society matter, Your Lordship. Your Lordship had directed this to appear under the normal heading today. Your Lordship will be taking the main matter. So, Your Lordship, can it be taken up tomorrow, Your Lordship, if it's if Your Lordship can take it up tomorrow, because Your Lordship, the urgency is that Your Lordship recovery. Your Lordship, then Friday, because the application day is Friday. The urgency is, Your Lordship, the recovery has happened and we have challenged the recovery proceedings in the CAN application, Your Lordship. That's why this application was filed.
In this matter, in this matter, I am appearing on behalf of the private respondent. My lord, what happened, my lord, on the last? No, my lord, it will. I would be prejudiced. But yes, my lord, the award has been passed by the insurance ombudsman in favor of me. My lord, I want, my lord, dismissal on merit, my lord. I have contacted with the, my lord, learned advocate who appeared. May I pray one thing, my lord, for last, my lord? There is the interim order, my lord, which
98. For the petitioner. I'm praying for at only 1 week time with the liberty to file a supplementary affidavit because during pendency of the writ petition, the petitioner got certain documents with regard to the selection process. No.
So because of our subsequent selection, he got the job.
But that doesn't take away my right to challenge the earlier selection.
No, that's true.
Subsequent selection process I have selected. The earlier selection process, 2018 selection process is under challenge, and all the petitioners did not get the job. But because all the petitioners did not get the job.
No, you are the
one petition, and if he selected in the earlier petition, then my lord, he will get the job and he will get the extra benefit of 2018 selection process. Subsequent selection process. Separate selection process was initiated in 2022. There he has been selected. The earlier 2018 is under challenge. But allow me to come back on the next date. I will try to satisfy your lordship and give me liberty to file a supplementary affidavit. May I take a specific instruction from my client? Because the gross irregularities has been made
in the same selection, we have challenged, and subsequently he has participated and got the job. Now he has continuing that the earlier selection was biased. Want to file a supplementary affidavit, then I also want to give opportunity to use this affidavit. Yes.
Opposition and reply. Okay. I'm good.
I'm for the petition.
19 I'm appearing to University Grants Commission.
My lord, they have used an a report, my lord. My lord, pay before your lordship sometime to exception to the report. My lord, I am not a my lord, cashier. Charge was handed over, but my lord, I discharge every day.
In this matter, I am for the school authority.
Yes, my lord.
My lord, what has happened? The
Yes.
school is governed by a special rule.
Yes.
According to the rule, if the managing committee decides something, there is an appellate authority. He can very well go before the appellate authority without availing that opportunity. The writ petition has been filed, and the charges against him is for defalcation.
Yes.
Out of 8 lakhs, he has paid back 6 lakhs. Nothing remains in the writ petition.
Then my lord,
I'll show. I have filed a
my lord,
report.
already all are paid. There is nothing. Your lordship observe that, my lord.
That is why he has been dismissed. He has admitted his guilt. He has. Yes. What remains, my lord?
Then they have I have exception. Kindly short reply exception to the report. They have annexed all the document. My fault. I have not able to contact so I last occasion I am not appear also.
When the matter is running in the list, he
Yes,
is not appearing.
My fault,
Yes.
Yes, madam. I have not appeared, madam. I have mentioned this matter. They have not mentioned, madam. I mentioned this matter, madam. Madam, you should give me some time, madam. To file the exception to the report, madam. And madam, your lordship had up the matter, madam.
Lordship kindly considers the rule once, because they have the alternative remedy also. Why I am submitting?
Yes, but
if the author, if the
I am not a cashier. I am the clerk, madam. Headmaster, madam, handed over the charge. And every day, my lord, I discharge and my lord hand over every accounts, my lord. But on and sudden, the suspension and my lord.
Kindly see, my lord.
I am not even a cashier. They have produced any document. I have by force, my lord, all are written and my lord. They have
my lord, kindly considers rule 12.
I
will
have
not submit
written,
it.
my lord, in fair, my lord, I return everything, my lord. I am in a penniless, my lord. At present, I am in the penniless.
It is agreed.
Yes, madam. Yes, madam. Yes, madam. 15 days, madam, or 10 days. 10 days, madam. 10 days. 10 days, madam.
Fine. Kindly make it returnable next week.
Lordship, I appear for the petitioner. It's a 2019 matter. The petitioner has been charged with
bank matter. Lordship, actually, the matter relates to Mr. Sudeep Pal Chaudhary. Actually, Mr. Sudeep Pal Chaudhary has expired on 2nd January 2026, Your Lordship. And thereafter, just today, bank has informed me on telephonic instruction to appear before Your Lordship. So, Your Lordship, the brief and others is not in my hand. Lordship, my humble submission before Your Lordship, kindly ask the petitioner to serve copy of the writ petition, opposition, and reply, Your Lordship, so I can proceed. Lordship, bank has not the copy.
And it's not that we have informed the bank before mentioning. We have also informed the bank last week. The matter will be coming up today.
Lordship, no doubt.
I will give it today only. Let the matter appear next Wednesday.
Lordship.
Let the matter appear next Wednesday, Your Lordship. Great.
My lord, I am for the petitioner, my lord. My lord, this is a matter for promotion from Group D to Group C, Lower Division.
Mr. Dhol is in this matter. My lord, I'm praying for a day's accommodation today. Mr. Dhol is in a fixed matter before court number 2. If my lord kindly allows me 1 day's accommodation, my lord. Deeply obliged, my lord.
What I for the petition?
Lordship, and for the state lordship, in the last order, lordship, petitioner placed time for filing exception. Response number 3, district inspector of school already filed. Everybody in opposition, lordship.
Reply has been filed against that opposition.
Sir,
Yes, that was served upon Mr. Badi. There is no difficulty. I can supply 1 more copy, but it has already been served.
for the patient.
Copy. Did I?
Read the patient.
But in that event, may I serve 1 copy because I have already served. It was served upon Mr. Badi, so I can serve and come back on the next date.
Next.
Your Lordship, this is my petition. I appear for the university. From the records, I find that there was a direction on the university to file an opposition. If you kindly grant me 2 weeks' time to file an opposition, I shall come back with a certain document needs to be placed before your Lordship.
You are appearing for the petitioner.
Yes, your Lordship.
Lieutenant. Learned advocate appearing for the Ravindra Bharati University seeks time to file affidavit in opposition to the writ petition. Full stop. As
I'm for respondent number 10, my lord.
But,
very briefly, my lord, the petitioner, my lord, was a teacher. My lord, he retired from school, my lord, in the year 2019. Lord, his retirement benefits, my lord, were not disbursed. He came before this honorable court. Lord, before this honorable court, my lord, two objections were taken. Lord, one, that there were certain irregularities that the school had reported against him. Lord, and hence, my lord, the school objected to disbursement of the retirement benefits. They said that no objection cannot be granted. But the second objection was, my lord, with regard to, my lord, fixation of pay scale. Lord, it was, my lord, alleged on behalf of the state that his pay has been wrongly fixed. The higher pay scale granted to him in the year 1993 was not entitled to him. Lord, this honorable court, Lord, recorded, Lord, an order, Lord, thereby deciding the issue of disbursement of his retirement benefits, overruling the objections of the school, that since you have not taken any steps during the subsistence of the tenure of the service, no objection can be heard now. So you release the pensionary benefits, Lord, treating him to be a past graduate. But the only issue thereafter which was kept open was whether he is entitled to grant of higher pay scale or not. Lord, in pursuance to that order, Lord, he is receiving, Lord, the pensionary benefit in terms of the past scale. Lord, I am only, Lord, inviting my Lord's kind attention to that order because that lucidly, Lord, records, Lord, the details. Lord, may kindly Lord, take order dated Lord, 10th of October 2023.
October.
My lord.
October 2023.
My lord. My lord is very kindly got it. Lord, kindly sees, Lord, the internal page 2. Lord, kindly sees the second paragraph, starting with the words, from the said report.
Yes.
From the said report, the observations of the respondent number 4 is quoted below. The school authority has been asked to submit the copy of prior permission obtained from the competent authority for acquiring MA degree. Then the school authority has been asked to submit the copy of staff pattern for the year 91, 92, 92, 93, and so on. The school authority has been asked to clarify in the matter of allowing increments to the untrained teacher appointed after 1/4/1981. But these will not were the objections. Now, Lord, kindly turns over the page. Lord, kindly sees the second paragraph starting with the word, the admitted position is.
Yes.
The admitted position is that the petitioner is the retired teacher in charge of one so and so. The petitioner had served the school as a past graduate assistant teacher for about more than 35 years. The school authority alleged various allegations against the petitioner, including misappropriation of funds and mismanagement of affairs of school. However, the record shows that no disciplinary proceeding was ever initiated against the petitioner at any point of time in accordance with the law or otherwise. The petitioner then acquired higher qualification, that is MA, and claimed the higher pay scale commensurating with his higher qualification. The disagreement arose between the petitioner and the respondent authority with regard to grant of prior permission by the jurisdictional DI. The respondent number 1 to 8 and the respondent number 10 contend that no such prior permission was ever issued in favor of petitioner, and hence there is no such prior permission exists either in record of the school or in the record of the jurisdictional DI. The respective learned counsel appearing on behalf of respondent number 1 to 8 and the respondent number 10, referring to document dated 28 March 2019, submit that the document itself shows there was no prior permission granted in favor of the petitioner. The document was addressed by the relevant school to the jurisdictional DI. However, there was nothing on record disclosed on behalf of the petitioner showing that there was no prior permission, there was any prior permission granted to the by the jurisdictional DI in his favor before the acquiring of the qualification. Be that as it may, the admitted fact is that after rendering services for more than 35 years, the petitioner has not received any of his superannuation benefit, even if the petitioner is taken to be a past graduate and without any higher qualification. After rendering the service of more than 35 years, the petitioner cannot be treated in such fashion in equitable view of this court. Considering the view above, this court has, as an interim measure, directs as follows. Without prejudice to the rights and contention of the petitioner in this writ petition, to the extent that he is eligible to receive a higher pay scale commensurating with his post-graduation degree, the jurisdictional DI of schools, respondent, that is respondent number 3 and 4, and the relevant school authority, that is respondent number 10, shall immediately take steps to release all superannuation benefits the petitioner is eligible to receive in law, taken into account as if the petitioner is a past graduate teacher, and for the time being, without considering the said higher pay scale to be granted to the petitioner, if any. The respondent number 10, then the consequential steps were directed to be taken for issuance of the pension payment order and processing it. Then the next page.
Yes.
The last paragraph. However, this writ petition hereinafter shall survive only for determination of the issue as to whether the petitioner had prior permission issued by the jurisdictional DI for acquiring master's degree, and upon such issue being finally determined, the next question shall arise whether the petitioner shall be eligible to receive higher pay scale commensurating with his master's degree. So today, the writ petition survives only to the extent of his entitlement to the higher pay scale. Now, so kindly see, after rendering 35 years of service, I have retired on 31st March 2019. I retired with higher pay scale. After my retirement, can an issue with regard to fixation of my pay scale be raised by the authorities? Is no more resident has been decided by a division bench of our court, and also by the Honorable Supreme Court. I shall directly come to those judgments after I indicate to my lord.
What is the order impugned here?
There is no order as such, because I came to this honorable court alleging inaction on the part of the respondent authority in non-dispersing my retirement benefits.
That has still not been done, because by way of an interim order it was directed.
Yes. So
the higher, whether you will be receiving the higher quantum or not, was the only point of determination that remained.
Right, and that issue cropped up in view of a stand taken by the state. The state took up a novel stand which was never indicated to the petitioner during the lifetime of his service.
That
your pay scale has been wrongly fixed. Put him to notice that we are going to refix your pay. He enjoyed it since 1993. Suddenly in 2019, after he has retired.
Wrongly fixed on the ground of non-sanctioning thereof by the DI.
Yes, the prior permission. Prior permission, my lord knows, came only after the 27th of November 2007 circular. It was not relevant then. And the larger bench decision of our court, says that it should be done in accordance with the then existing prevalent rules.
In any case, since you were granted those benefits even without there being any sanction or whatever it is.
Yes.
And it continued throughout your service period. After retirement, you are relying on Rafiq Masih.
Rafiq Masih, the fundamental argument which I rely on is there is no master-servant relationship. They can't revisit. They can't revisit that relation again. One decision this is an unreported decision of our division bench. But kindly see paragraph 5. Mr. So-and-so appearing on behalf of the appellant said that this petitioner joined the school as an assistant teacher in social science group with so-and-so qualification. Thereafter, permission was given by the managing committee of the school to the appellant for higher studies, and accordingly, he obtained MA from the university. The appellant applied for getting postgraduate pay scale, which was approved by the managing committee, and he was given postgraduate pay scale in salary since 1st of June 1999 till the date of retirement, that is 31st of March 2019. The salary being sanctioned and released after verification of the documents by authorities concerned and he got the pay scale for a period of 16 years and nobody raised any objection against his postgraduate pay scale. As such, the respondent authorities are bound to sanction and release the pensionary benefit based upon such last on salary of the appellant in postgraduate scale of pay, and denial of the same is violation of the principles of natural justice. Lord, this was not the argument and the substance, sum and substance of the background of the case. Lord, kindly comes to paragraph 8. Paragraph 7, as desired by my lord, Rafiq Masih is
that is the Rafiq Masih is the
foundational
foundational
case.
judge.
Paragraph 8. Admittedly, the appellant petitioner got postgraduate pay scale in his salary since 1st of June 1999 till his date of retirement on 31st March 2025. The salary being sanctioned and released after verification of documents by the respondent authorities. For such prolonged period of 16 years, respondents never raised any objection against the postgraduate pay scale of the petitioner. It is also admitted position that this present appellant petitioner has no role in the fixation of his pay scale. There is no allegation against this petitioner for suppression of material facts of filing false document. It is contended by the appellant that he got permission from the managing committee of the school and thereafter he obtained postgraduate. Nothing has been brought on record on behalf of the authority that this appellant petitioner was responsible for pay fixation, and fraud or misstatement has been made by him. There is nothing on record to show that there was an error, miscalculation, mistake. This appellant petitioner was never responsible for such pay fixation. On the other hand, such pay fixation was made by the authority concerned. After obtaining postgraduate qualification, the salary of this appellant
The same thing has happened in your case also.
My lord. And then, the paragraph 10 to 12, finally in 12, then the appellant was not responsible for pay fixation, and such pay fixation of the petitioner was made by the authorities. He cannot be held responsible for such pay fixation. No objection was raised by the respondent state prior
Yes,
to his
madam.
My lord, a leading advocate engaged in a court number 18. Kindly.
You should have said so in the beginning only. There is a prayer for time. You should have indicated in the beginning. We would not have proceeded forward.
Like, if may I ascertain if the learned counsel can come anytime in course of the day. But kindly will not keep it not passed over for some time.
Because 3 p.m. we'll be taking up original side. If another matter is taken up, you may not get an opportunity. I am recording whatever I have heard.
Any day, my lord.
Any day means next Wednesday again. Hearing matters Wednesdays. Likeness. Heard Mr. Chaturvedi, learned senior advocate, appearing for the petitioner. Full stop. He has opened his submissions but is yet to conclude. এটা কন্টিনিউইং হিসেবে উপরে করে দেবেন এই যেটা চলছে Who is appearing? CGST or SGST?
CGST, my lord.
Mr. You are not there.
No. It was hard, my lord, with the Honorable Justice Mr. Nijamuddin, my lord, on several occasions. It was Mr. Maiti appeared, and my
So KK Maiti was there.
so that is I am not. My lord can engage somebody, otherwise, my lord, it was we are basically asking for refund or Maiti ka chilo. Mr. Maiti appeared.
Because we are seeking for refund, but we are waiting for from 2020, my lord. Difficulty we are facing, my lord.
Mr. Bhonjo, you can take instructions, isn't it?
I shall take instruction whether any senior council has been
I'm
engaged.
recording
No,
that.
I
If
can
nobody is
hand,
there, you will get the brief.
I can provide him all the copies of the opposition reply, everything.
লিখে নিন।
Agar instruction.
None appears. None appears for the respondent CGST authorities. Full stop. List this matter on February 18th,
Here there is a direction for exchange of affidavit. My lord, affidavit in opposition has been filed, though after 5 years, my lord. We have received it on 31st January. My lord, the reply has not been filed, my lord. I am seeking the extension of 1 week time, my lord. We'll file the affidavit. Then, my lord, can keep it.
He's taking time to file reply. You are saved. Learned advocate appearing for the petitioner.
Because they were not giving the affidavit. They were not giving the reply.
Can I dispose the can then, or will it remain pending?
It can be disposed of.
Can one
It has no bearing in the final.
দেখি can one ফালতু ফালতু পড়ে থাকে।
এই ক্যানগুলো দিন আমাকে ক্যানের কপিগুলো আছে তো ডিসপোজ করে দিন।
ক্যান আছে কি ফাইলে? ছেড়ে দিন কল করুন, কল করুন, ক্যানটা আনিয়ে নেবেন। আচ্ছা তাহলে দিয়ে দিন। আছে লিখে নিন তো।
Now, 907, I beg to appear for the petitioner. On last occasion, my lord has directed me to serve a copy upon my learned friend. He is here, my lord. My lord, the matter notice has been served. My lord, the matter pertains to some admitted claims of the petitioner, my lord, which has been given subsequently during the pendency of the only the bank guarantee has been withheld, my lord. The payment part has been paid by the respondent authorities. My lord, the bank guarantee has been withheld. I was only beseeching if my learned senior friend can come up with an
So Banerjee,
instruction
if you can take
with regard to
instructions
bank
whether
guarantee.
they are going to
I
withhold
will
or
take
whether they are
instruction,
going
but
to release.
generally what I say, when he completes a tender or he participates in a matter, he completes and then all bills are being paid to him. Now we hold the bank guarantee for a period. We call it a defect liability period. If something comes within that period, then the liability of that
My lord,
defect goes to him.
probably I will take instruction on that part also.
If your lordship says me can dispose of the matter, giving me a direction to take call on the issue, I will pass an order to
My
him.
lord, kindly do not dispose of. Kindly let me come back with the instruction with regard to the defect liability period, my lord.
Learned advocate appearing for the petitioner submits that although substantial payments which were due to the petitioner have been made.
Every payment I have done, only the bank
Payment, all the payments on the
that
bank guarantees.
although payments due to the petitioner have been made.
I need to take instruction.
That although payments have
I
been
need to
made
take instruction.
to the petitioner,
Come back with
payments
proper
due.
instruction, or else
That
हमारा
although
भी
payments
करना
due to the petitioner have been made by the respondent railway authorities.
होगा। Defect liability.
No, respondent Eastern Coalfields Limited.
My lord, ECL,
Eastern
my lord.
Coalfield Limited. Yet, comma, it was a performance bank guarantee.
Performance bank guarantee, my lord.
Yet the bank guarantee that had been put in by the petitioner is still lying with the respondents. Full stop. It is submitted that the same may be directed to be released. Full stop. Mr. Banerjee, learned advocate appearing for the respondents, seeks time to take instructions on the aspect of the bank guarantee. Full stop. List this matter. When should I keep it?
Any after 10 days time, lordship.
List this matter on February 25, 2026.
My lord. My lord.
To enable
In the
Mr.
meantime, my lord, I
Banerjee
shall also come back with instruction
avail
if the defect
proper
liability period is
instructions.
over or not.
Very well.
I'm deep.
Grateful, lord.
So, next. Keep Shankar Banerjee.
Let I appear for the writ petition.
Yes.
That the challenge in the writ petition is an order which has been passed by the Directorate of Revenue Intelligence. This is the order dated 27th April 2020. But before I take your lordship to that order, my lord, the challenge is twofold. Primarily, my lord, on the ground of violation of natural justice. And my lord, the ground taken to allege violation of natural justice is, my lord, twofold. One is hearing was concluded on 14th of April 2019. An order was passed on 27th April 2020. That is more than a year after the hearing was concluded. And my lord, we are covered by a judgment that in such cases, if it crosses more than a year, that itself is violation and it has to be reheard. That's number one. Number two, my lord, in this aspect, there is already a notification given that if hearing is concluded, you are to endeavor to complete and give the judgment by 1 month. That notification is also there. Now, before I take your lordship through the on merits, because now we are after completion of affidavit. If lordship takes the affidavit in reply first, may I just show your lordship the order of the appellate court? Because initially, my lord, we were unable to get an ad interim order of stay. And in fact, my lord, due to alternative remedy, the writ petition was initially dismissed and we preferred an appeal therefrom. I first want to show your lordship the appellate court's order. My lord, that lordship will find in the affidavit in reply at page 10.
Yes, the adjudication order was stayed and the order passed on the writ petition was set aside. Matter was remanded to the writ
Correct.
for hearing afresh.
Correct. And my lord, lordship will get the dates also that when this has been done. My lord, kindly see page 3 of the order.
Yes. Hearing was concluded
We
on May
notice that
14.
under clause 6 of the circular dated 1st June 2009 issued by the Central Board of Excise and Customs Department of Revenue, Ministry of Finance, Government of India, it was provided that in all cases where personal hearing had been completed, the order was required to be made by the adjudicating authority within a month from the date of personal hearing. In this case, it's an admitted position that hearing was concluded on 14th of May 2019. Written notes of argument were filed by the appellant on 21st May 2019, but the adjudication order was pronounced on 27th April 2020, nearly a year after conclusion of personal hearing. Mr. So-and-so, learned advocate for the appellant, submits that adjudicator had very little recollection of the proceeding before him before making adjudication, as would be apparent from his order. Then, my lord, my learned friend's submission has been recorded, and my lord, prima facie case, my lord, lordship would find what this is there.
Yes.
Now, my lord, before my lord, this is because, my lord, in a writ petition, I'll give your lordship the background of the issue. But, my lord, in a writ court, I can't argue possibly on merits.
Procedural fairness.
Yes, I can't argue on merits, but what I would endeavor to show that because of the passage of time, my lord, the adjudicating authority perhaps got confused, and my lord, at one page, it's a longish order, 150 pages order, more than 150 pages order, 222 pages order. But when at one page there are findings that my client is a victim of a fraud perpetrated by somebody else. And my lord, the ultimate conclusion is that it has been treated to be an import made by my client, and duty has been imposed on my client with penalty, and the one who has perpetrated fraud and the finding is there, my lord, only a token penalty of 3 lakhs have been levied. This is the anomaly because, my lord, by the time, my lord, the adjudicating authority has gone towards the end portion of the order, my lord, he has completely lost track as to what he had earlier held. Now, my lord, to cut a long story short, I'll just give your lordship the background of what the issue is. I'll not argue on merits, just the background. My lord, my clients are importers of, my lord, rubber in liquid form. Now, rubber in liquid form, since it's in liquid form, that it comes in containers. And my lord, the containers in which the liquidified rubber is there, my lord, it's shown because it comes in containers, my lord, the containers are, my lord, classified as packing materials. It comes in containers. And my lord, these containers are supplied by, and they are, my lord, worldwide supplies of an entity primarily in Singapore, which also has a subsidiary over here. You know what a good pack? Good pack Singapore. But it's called Good Pack Singapore. So the understanding is the rubber comes in containers. Well, Good Pack has a revolving arrangement with us. We bring it, we take out the rubber, containers are taken by Good Pack, and my lord, it's taken away, and again, it's a cyclical process. We have nothing to do with the containers. But admitted position, goods imported are rubber. There is no dispute that I have paid the requisite customs duty and all levies and everything so far as the goods that I have imported. Now what happens is, well, a fraud is discovered in the sense, why I call it a fraud, or an anomaly is discovered that this Good Pack Singapore, what it was doing, it was bringing in the containers by, my lord, as a packing material for various liquids, and while it was taking back the containers from my clients, it was not again exporting it out. It was utilizing those containers, for other shipments, which of course we have nothing to do, because, my lord, Good Pack, they are the owners of the container. They are the owners of the container. So, my lord, the finding is that Good Pack has hoodwinked both the customs authorities and also taken the gullible importers for a ride, piggybacked on them, and have brought in the country the containers. It was shown as packing materials, and it has taken them back and it is being utilized as domestic containers. So in effect, a container has been imported from outside into India, and since Goodpack is utilizing it, it has not paid the corresponding duty for containers. And the charging section which has been invoked is a charging section for import of duties on these containers, not on rubber. This is in short, my lord, the gamut of dispute. Now, my lord, I will show your lordship. Now, lordship comes to the impugned order, just 4 or 5 paragraphs, that why, my lord, one portion of it cannot be supported by the ultimate finding of it. And then, my lord, I will come. My main clause is it's more than 1 year, and I will show what the point, what defense they have in their affidavit in opposition. My lord, the order starts, order dated 27th April. It starts at page 137. Kindly first come straight away to page 150. It's a longish order. I'll just trouble your lordship with 5 or 6 paragraphs.
One 50.
150.
Yes.
Para 1.8, which starts as Goodpack India. Lordship finds that?
Yes.
Yes. Goodpack India and GDPK were subsidiary companies of Goodpack Singapore. Their sole source of revenue was leasing of metal boxes. Yet till the time the case against them and importers had been booked by DRI, they had not imported any metal boxes or IBCs. Well, IBCs are bulk containers. Intermediate bulk containers. These are IBCs. That is, my lord, the carton or the box in which liquefied rubber or, my lord, any liquid items comes by way of ship through transshipment.
Yes.
They had not imported any metal boxes or IBCs into India and had used only illegally imported metal boxes for their lease business. GDPK's first import consignment of metal boxes arrived only in April 2016. However, they had been earning huge amount of revenue even before this on the basis of leasing out in India illegally imported metal boxes. As per Statement of Profit and Loss as at 31st March 2016, revenue from operations of GDPK was more than 39 crores. Out of this, more than 38 crore revenue was lease income. Not only GDPK, Goodpack IBC Singapore also earned huge amount of money from leasing operations through GDPK Goodpack India. As per para 3.4 of IBC lease agreement between Goodpack Singapore, the metal boxes leased by GDPK to customers in India were simultaneously on lease to GDPK from Goodpack Singapore. During 15-16, GDPK statement of profit and loss revealed lease expenses of more than 7.5 crores. So not only GDPK, even Goodpack Singapore earned their revenue from IBCs, which were illegally imported into India. GDPK were not liable to utilize or lease IBCs imported into India by importers under provisions of notification so and so, as the said IBCs had to be re-exported within 6 months of import, and that too in the name of the importer, and hence they were solely dependent upon illegally imported metal boxes or IBCs for their Indian lease business. Sri Vikas Upadhyay had confirmed this fact in his statement dated 10th August 2017. So the only category of imports they had been leasing to their customers in India were the IBCs, which were imported illegally without being declared before the customs. Due to such illegal imports, Goodpack India and GDPK got enough number of IBCs for leasing in India, and that too without having to pay any duty thereon at the time of import. So, my lord, in essence, I am not going into whether correct or incorrect. The entire grievance or the scope of inquiry was these coming into the country of these boxes, and my lord, these are leased boxes, because my lord, my arrangement is, because I am bringing liquefied order, I take it on lease. So long it is on the ship and it is with me, Goodpack charges me an amount, I pay that, they come, their representatives come, take the boxes again and takes it back. Now, technically it is supposed to be re-exported. But I am not concerned with that in the sense that it is Goodpack which does it, because they are charging lease rental. The sum and substance of the allegation is that Goodpack was bringing this in, but was not exporting it out, and instead utilizing these boxes for carrying out his business in India. Now, the next 1.8.1, page 151, kindly see the last sentence, just before para 1.8.2. Therefore, it was clear that Goodpack India and GDPK deliberately promoted illegal import of IBC without payment of duty and earned huge sum of money from the leasing thereof.
Yes.
This is the finding. Now straight away kindly come to page 155. (1.9.4), I will not read out the entirety, kindly marks the heading Role of Management of Goodpack India. How, my lord, it has done whatever it did, my lord, it has been enumerated over here. And then, my lord, kindly straight away come to page 303.
Yes.
5.1.7.2. I find that section 111J of the Customs Act covered confiscation of any dutiable or prohibited goods removed or attempted to be removed from a customs area or a warehouse without permission of the proper officer or contrary to the terms of such permission without prejudice. I find section 111J is not applicable in the present case. The imported 5.1.7.2. This should be page 303. I find that section 111J of Customs Act covered confiscation of any dutiable or prohibited goods removed or attempted to be removed from a customs area or a warehouse without permission of the proper officer or contrary to the terms of such permission. Without prejudice, I find section 111J is not applicable in the present case. The imported packing materials, that is IBC or metal boxes, are not prohibited goods. It is another matter that customs officer permitted the clearance of synthetic rubber, and under the said clearance, the IBC metal boxes also got cleared from the customs area. My lord, kindly marks this. So, my lord, when I am importing my liquidified rubber, I am saying these are liquid rubber in these metal boxes and I am asking for customs clearance. Customs officers clears the goods. There is no demand on me regarding non-payment of customs on rubber. That is not the case. The fact is that synthetic rubber and IBC metal boxes were composite unit, and Phoenix suppressed true fact of packing material being returnable and durable from the customs officer to mislead. Hence, I find that the provisions of... Now, my lord, kindly see in my declaration. Box se ache hota. My junior will, I'll just come back. But when I just note that 2 lines before that, the finding is that I have declared this synthetic rubber in, my lord, boxes, IBC containers. Rubber cannot be without the container. Liquid rubber cannot be without the container. The declaration mentions that, and, my lord, it has been passed by the customs. Now the finding is, because Goodpack has done that, I have colluded, I have deliberately shown it as packing material. My lord, pausing here for a moment. Whatever may be the... My lord, can liquidified rubber be brought in anything else but container? And if container comes in, the description has to be packing material. And if anybody has done the mischief, you 100 pages before have already said who has done the mischief. Now, after all these findings, kindly come to page 339. 2 more paragraphs I'll just show you. Kokon. Oh, my lord, I am sorry, my lord. I am told Lordship has original side matters. It will be, my lord, any tomorrow if Lordship want, whenever Lordship takes.
Next Wednesday.
I'll come back. I am sorry, I did not know.
लिखे नहीं.
I'll just show one more paragraph.
Heard Mr. Chaudhary. দিদি এই একটা কন্টিনিউইং ছিল, এটাও একটা কন্টিনিউ করে দুটো উপরে করে দেবেন, যেগুলো শোনা হচ্ছে তাহলে শোনা হয়ে যাবে, নাহলে আবার পেছনে চলে যাবে। তাহলে এটা সেকেন্ড কন্টিনিউইং ম্যাটার হিসেবে রেখে দেবেন। 25, হ্যাঁ, তাহলে এটা 18 তারিখে উপরে চলে আসবে, কোনো কন্টিনিউইং ছিল তাহলে হয়ে যায় ম্যাটার। রেখে দিন।
Next matter 909, I was praying that let it be kept on Wednesday week on 25th February. But next
ওটা 25 তারিখ করে দেবেন।
909. I'm grateful.
For judgment গুলো করে।
I am for the petitioner, my lord.
Yes. I have disposed of the writ petition. I have disposed of the writ petition, sent the matter back for consideration. The chief judge will give a fresh opinion in accordance with Ramchandar and Lakshman Naskar, and the state authorities shall reconsider that and pass appropriate orders.
Yes.
Given my reasons, you will get to
Very
know
well, my lord. My lord has fixed a timeline for that.
Yes. I have fixed a timeline. I have fixed
Very
a
well.
timeline. Timelines are strict. You will be able to get.
Very well, my lord. I am deeply obliged. I am grateful.
Thank you. And Mr. Devra, I have recorded that you have adopted the submissions of Mr. Galib. I have indicated.
Same line.
Same line. I have said that because Mr. Galib had made the submissions, I have recorded you have adopted his submission. I have dealt with your judgments. You will be
Yes.
able to see it.
Very well, my lord. I am grateful, my lord. Deeply obliged.
Thank you. Yes.
Kindly allow me to mention one matter. But I'm mentioning this matter upon notice to the other side. So being item number 117 of the day. But I'm praying for upgradation of this matter.
117 hearing matter.
117. Lordship has directed the defendant to file affidavit of opposition on 30th January, but till date nothing has been filed by the defendants. So may the matter be upgraded so we can be proceeded further.
We shall see. There are a lot of motions. Hearing will upgrade later. Yes, let us see.
Kindly consider.
I'll consider it.
Yes.
Good.
I will.
Sure.
Listed matter under application serial number 1. Comply with expression state.
May it please your lordship, this is my application for extension of the interim.
Madam, I haven't received any application copy. You haven't served any copy.
So I was in doubt what kind of application has been made. Whom have you served? Just show you. It's been yes, served on Banerjee.
Yes.
Oh.
It was served, lordship.
Yes, they served upon me, it seems. Onward to me. That is sufficient. How can I appear without it? No. I will talk to the department. Don't worry. I will regularize.
Lordship will kindly take up the last order, lordship, appearing on page number 15.
Yes.
Lordship, the interim order was lastly extended till the end of December 2025. Thereafter, Lordship, the matter never appeared in the list, Lordship.
You could have mentioned it for
Lordship, we sought for instructions from the client. We got it at a later
very well.
date,
I'm reimposing since it was there. Is there any change in circumstances in between?
Lordship,
we have to also take instruction because
My lord, there has been no, as far as the assessment is concerned, I have no such instruction. That means that
Because if an assessment order or something of that sort has
Yes.
happened in meantime.
Lordship, the 147 order has been already passed
Acha.
by the JA. The Supreme Court is in season of the matter. 148 passed by the
What
JA.
was the challenge here? You had not challenged the notice, you had challenged the 147 order.
No, I have challenged both. I have challenged the notice.
notice.
148.
Petition was admitted.
Then you are saying 147 order has been passed?
No,
147 is assessment.
Assessment.
Then assessment has been done.
No. Thereafter, it has not been done.
That is what I'm saying. If assessment has been done in the meantime, because 2 months have passed.
Right.
If they have passed an assessment order, then in that case you will have to take different action because for your inaction it went out.
Lordship,
you take instructions, come back tomorrow. I'm making it not today.
Lordship, I'll just indicate, Lordship. Just gives me a moment.
Your indication will not do. You have to be sure as to whether any change has happened or not. I will record that. in
Ma'am,
the order.
that will be perhaps something, Lordship, that the department would.
You also have to check it. Everything is uploaded on the portal. You have to check it on the portal and come.
Lordship, till day, as per my instructions, Lordship. Lordship, the assessment order was passed. It was passed
Be
in
clear.
2022.
Read copy it into. You are not clear in what you are submitting. Once
Lordship,
you say
I'll just
assessment
indicate,
order is
Lordship.
passed.
The assessment order was passed.
148 order are you challenging 148?
I am challenging 148 passed by the JO. That is my ground of challenge.
148 is not assessment order. 148 is notice.
148 is the notice, Lordship. I'm
Yeah.
challenging the notice. But
Then-
147 order has been passed.
Lordship, 30th March 2022.
It was passed, Lordship. I just indicate.
আমাকে একটা copy দিন।
Which page?
That's what they are writing in the
indicate.
See. 30th March 2022. That's what they are.
Thereafter, the notice was issued.
No. The
Thereafter,
148
subsequent
is 2024. How can assessment order be 2022?
Oh, I'm sorry. I'm extremely sorry, Lordship. I'm extremely sorry.
You are not posted with the fact.
Lordship. The 148 notice was passed on.
You take instructions, come back.
The reassessment order has not been passed, Lordship.
You are not sure about it still.
Lordship, kindly keep it after a week's time.
No. I'll keep it tomorrow. In a week, what will happen, nobody knows.
Lordship, may I just humbly submit on this, Lordship?
Tomorrow.
Lordship.
This is an application for reimposition of the interim order that expired on December 31, 2025. Full stop. Learned advocates appearing for the respective parties are requested to take appropriate instructions as Yes, I had kept it for my own purpose that I'll go through it and if I have some queries, I'll ask. Yes.
No, last occasion. Normally my juniors are there. I don't know. Actually, I was out of station on that day.
Yes.
But Lord, next week I will not be here. I'm going on religious tour for a week. Lord, by Friday I will be back. So week after that can be. 23rd is Monday. Let it be on Wednesday. 20.
Yes, yes. Your Lordship passing any order? No, just simply. No, grateful.
My lords, this matter, my lords recalls, the notice was issued to the non-existent entity, my lords, my lords.
But my lord,
Fine. Fine.
but my lord, before issuing that notice under section 148, the competent authority gave the approval for issuing the notice under section 148. And my lord, notice under section 148, my lord, the assessing officer directed to file the income tax return within 90 days. But they have not filed any return. They have not asked. My lord. Yes, my lord. Only thing, my lord, they have not filed in the return on the relevant assessment year is a block. It is required to file the return as a block.
My lords, any proceedings, my humble submissions are any proceedings cannot be against a non-existent entity, my lords.
They should file the return within bracket non-existence block in another. Well, I have read. Yes, my lord. But my lord, they have served a notice in Form 9 under Section 234. Thereafter, we have not yet received any information. So, my lord, my respectful submission, my lord, as per GKW's case, my lord, the management submit the objection and the assessing officer beside that objection.
My lords, may kindly come to page number 18, my lords. 18, my lords.
Page 17, my lord. First 17.
3rd of July, 2023, my lords.
No. And
the change. As they are party to the proceedings, we have informed them that this particular change will be there. If my lords. Page number 18, my lords, we have served them that this company is being amalgamated to Mascara Properties. Now, my lords.
But
my lords.
But my lordship, my humble submission, my lord, the SSC should file the return for that relevant year and furnishing all the information and with the amalgamation. And
My lords, it is well settled. My lords, they have accepted the fact, and my lords, they have passed a transfer order also. My lords, if my lords permits, I will file the supplementary affidavit bringing on records the transfer order also that has been passed by them. My lords, any notice or any proceedings, my humble submissions are, my lords, it is well settled that any proceedings can be only against the existing transfer order. My lords, I am not carrying right now, my lords. Preceding, my lords. My lords. My lords, then my lords may kindly give me. My lords may kindly give some time for filing supplementary, my lords. My lords.
But more, yes, ma'am. Moreover, my lord, the SSC should file the return with all information. No, my lord, I am not saying, my lord, not particular in the assessment year, but my lord, when the amalgamation on that year, my lord, the SSC should furnish the return with all information regarding the holding status. And my lord,
My lords may kindly give week's time. I will bring all the related documents on. My
and
lords.
my lord,
I'll
all the
bring.
decisions, my lord, though I am not bring, all the decisions is in favor of my learned friend. Against the transfer company, notice doesn't lie. But not in all the cases, my lord, the SSC file the return with all information and under the holding status the return. So, my lord, if the SSC file the return stating as a holding status, well, I have no case.
Very well, my lords. My lords may kindly give a week time. I'll bring everything on record.
Yes,
My lords.
yes, yes, my lord.
My lords, that.
Within 2 or 3 weeks, they will decide after opportunity of hearing. Yes.
That
Yes,
can be
yes,
done.
my
my
lord.
lords.
Yes,
My
my
lords. That can be done.
Yes, my lord.
My lords, that can be done. My lords.
Yes,
My
yes,
lords.
my lord.
That can be.
That kind of should can be. Yes, my lord.
My lords.
Not angry.
Milord, Milord, I represent, Milord, the petitioner item number 6. Milord, would your lordship only
Milord, would your lordship, my lord, just give me 3 minutes time, my lord, I'll be physically before your lordship. I'm running, my lord. Kindly accommodate me for 3 minutes.
I told him. What does it? প্রথমে একটা জাজমেন্ট দিয়েছিলাম এটা Harish Priyandas.
Yes, my lord. Yes, my lord. May I continue, my lord? I will divide. My lord, in this case, there was a penalty on an employee of the firm, the substantial amount of penalty, and we are saying, based on the upon adjudication, that he was one of the main persons, main culprits who has done this. Based on that, he was penalty amounts were fixed on him. Now he says that he has left that job, and he says that he doesn't have the amount of that kind of wherewithals, financial wherewithals, to be able to pay that kind of pre-deposit, which is 7.5%. And he says that there should be that pre-deposit should be waived in appeal, and he can file the appeal without the pre-deposit. And he has, apart from that, he has come before my lord to quash the order. Apart from that, he has come before my lord to quash the order. My lord had pointed out, the question of, first of all, jurisdiction comes. You have an alternate remedy. It will go before the in the appeal division, and that's when the question of pre-deposit came in, saying that pre-deposit is onerous and he cannot pay that, and appeal remedy should not be stopped. Now, my lord, at that point of time, on the last occasion, I had placed one judgment of the Bombay High Court, which had upheld the vires of the section 129E. My lord, may I just refresh that judgment? Couple of paragraphs allows me to place. I'll give you.
We have an extra copy. We have an extra copy.
Okay, they.
For the judge.
Judge.
The judge, we don't have an extra copy. Maybe this.
I had maybe.
Maybe this one we will give marks ke saath because this is way too tight.
Oh, that's okay. This is
very, it'll be difficult to.
अच्छा कॉपी किया थी नहीं ना जॉर्ज साहब की दी I'll give it to you.
Should I read out?
That's okay. That is slightly light. Once I finish this, I'll give it. Well, this is 2017 SCC Online Bombay 3013. My lord, kindly it is 2. My lord, will kindly come to paragraph 2 of this judgment. Here, section 129 was challenged, my lord. May I place this one before my lord? The principal prayer in the present petitions is a challenge to the constitutional validity of section 129E of the Customs Act 1962, as amended by the Finance Act number 2 of 2014 and brought into effect from 6th August 2014, prescribing a mandatory pre-deposit for filing an appeal before the tribunal or the commissioner appeal. The petitioners are also challenging the common order in original dated 22nd January 2016, passed on the show cause notice dated 24th August 2015 on the ground that the order is illegal, being passed without considering the submissions of the petitioners. But similar situation. And then they went on to challenge section 129. I will kindly come to paragraph 10. My lord has paragraph 10. As seen from a plain reading of the provision, section 129E provides for deposit of certain percentage of duty, demanded or penalty imposed or both. As a condition precedent for the appellate authority to entertain an appeal, subclause 1 and 2 of section 129E mandates deposit of 7.5% of the duty demanded or penalty imposed or both in case of an appeal before the commissioner appeal section 128 and before the tribunal under section 129A respectively. Clause 3 of section 129E provides a deposit of 10% of the duty demanded or penalty imposed or both in pursuance of the order appealed against. The first proviso provides that the amount which is required to be deposited under this section shall not exceed rupees 10 crores. The intention of the Parliament in amending section 129E by the amending act in question needs to be noted. Prior to, my lord will kindly see this, prior to the amendment, in view of the powers and discretion conferred with the appellate authority to waive or dispense with the pre-deposit, substantial time was expended on the adjudication of such application and in deciding issues as to whether the contention of the applicant in the stay application of an undue hardship is being caused could be accepted to grant an appropriate waiver. Resultantly, orders on the stay application generated further litigation before the higher forums, taking a toll on the valuable time of the tribunal, delaying the adjudication of the appeals. This undoubtedly caused a serious prejudice to the parties before the tribunal. Thus, the aim of the amended provision is also to curtail litigation which had assumed high proportions, leaving no time to the appellate authorities to devote the same to important issues. Considering these hard realities and to have an expeditious disposal of the statutory appeals, which undoubtedly is a necessary requirement of effective trade, commerce, and business, the Parliament, in its wisdom, amended the provision of Section 129E of providing deposit of 7.5% and 10% respectively, as subclause 1, 2, and 3 respectively provide. If such is the aim and insight behind the provision, it certainly cannot be held to be unreasonable, onerous, unfair, or discriminatory for the twofold reason. Firstly, the object of a public policy sought to be achieved by the amendment, namely speedy disposal of the appeals before the appellate authority, is a laudable object and cannot be overlooked, so as to label the provision as unreasonable and onerous and violative of Article 14 of the Constitution. Secondly, that the amount which is required to be deposited is not unreasonable from what the earlier pre-amended regime provided. So, my lord, earlier you had the right of appeal only if my lord kindly remembers the bank tribunal cases, the securitization, the recovery to debt tribunal act matters. The appeals used to be there also. You had to pay everything and appeal. You had the right to have appeal. Similar, absolutely similar provision in perimetry. A provision was there here in the Customs Act also, that you could come on an appeal upon payment of. Now there was one lacuna in that section where based on which the notices used to go before file applications for pre-dispensation of stay, etc. So what used to happen was sometimes they were rejected, or sometimes they used to be minimum of 20%, 30%, 15% payments, etc. On very rare occasions, a complete waiver was given. Now, looking into that aspect, as this paragraph clearly notes now, public policy decision was taken. No, this is causing delay in the process, and a one-time 7.5% with regard to when going to the tribunal and 10% when going to the commissioner. This was what was framed specifically, and that was the question before the Bombay High Court, and Bombay High Court clearly said that no, this is reasonable, and it is not affecting Article 14 at all. Now, my lord, carrying on from there, the next two paragraphs I'll place. Now, the discretion for dispensation was completely done away in the statute, in the particular provision 129E. Paragraph 12, my lord, kindly reads with me. The contention of the petitioner that the provision is rendered discriminatory as it creates two different classes when it mandates pre-deposit of duty demanded or penalty imposed or both, and more particularly when penalty cannot be considered to be a revenue as it is not a tax requiring it to be safeguarded, also cannot be accepted. it may be pointed out that even the pre-amended provision stipulated for a deposit in case of appeals from orders levying penalty. This submission of the petitioner also cannot be accepted considering the decision of the Supreme Court, refers to the Supreme Court decisions, which lays down that right to appeal is a statutory right and not an absolute right, which can be circumscribed by the conditions in the grant. Other judgments were referred, and then Supreme Court judgment was referred, and referring to the earlier decision in Anant Mills versus State of Gujarat, held as under, it is well settled by several decisions of this court that the right of appeal is a creature of a statute, and there is no reason why the legislature, while granting the right, cannot impose conditions for the exercise of such right, so long as the conditions are not so onerous as to amount to unreasonable restrictions, rendering the right almost illusory. Thus, by virtue of Section 129E, the right to appeal as conferred under the said provision is a conditional right. The legislature, in its wisdom, has imposed a condition of deposit of a percentage of duty demanded or penalty levied, or both. The fiscal legislation as in question can very well stipulate as a requirement of law of a mandatory pre-deposit as a condition precedent for an appeal to be entertained by the appellate authority. In view of the above settled position in law, Section 129E of the Act cannot be held to be unconstitutional on the ground as assailed by the petitioner. My lord, this was the crux of the, and it was upheld. The variance was upheld, and my lord, no appeal was made against this judgment. And my lord, no, my lord, Kusum in Gods very clearly says that once a virus is upheld, that will be the law. That may I show Kusum in Gods, my lord? The Kusum in Gods. Yes, I think. Kusum in Gods. Yes. Yes, 2004. Kusum in Gods. In fact, on the last day, I had given these two judgments, Kusum in Gods and this judgment. And maybe I have misplaced it. My lord, Kusum in Gods. At a copy there. Copy name. Huh? My lord, may I place it and then paragraph 21 and 27, my lord, of Kusum in Gods. Yes, my lord. Yes. For that, for this and for forum inconvenience. Now, my lord, thereafter, my lord, will এটা খুলতে দেখাচ্ছি copies. My lord, I'll refer to another couple of more judgments of this court, my lord, in a moment. Pre-deposit aspect, where and here in this case, my lord, this is writ petition WPA 3418 of 2025, Ziauddin Ali versus Registrar, Sestat and others. Now here, instead of 129E, 35F is referred, which is imperi material, 35F of Central Excise Act, which is imperi material to 129E. This is a coordinate bench judgment, my lord. My lord, kindly come to paragraph 7. My lord, has paragraph 7? Having regard to the clear mandate provided for in section 35F of the said Act, and also having regard to the judgment delivered by the Honorable Division Bench of this court, presided over by the Honorable the Chief Justice, in McLeod Electrical Enterprise versus Additional Commissioner of Central Tax, CGST. In my view, there is no scope for this court to entertain this writ petition. I am also of the view that the tribunal cannot be directed to hear out the appeal in contravention of the statutory provision. The argument that the writ court can waive the condition and relax the condition for payment of pre-deposit is unsustainable in law, having regard to the specific statutory precondition provided for entertaining an appeal. And unless such condition is met, the same does not authorize the tribunal to hear out such appeals on merit. Although Mr. Gulani, by referring to the judgment in case Muhammad Akmanuddin Ahmed, has attempted to make out a case that the High Court is competent in a fit case to waive the precondition or grant a right to prefer an appeal, I, however, find that the issue that fell for consideration in the said judgment was the constitutional validity of Section 129E of the Customs Act, and for a direction upon the respondents in the said case to admit the appeal filed by the petitioner without the predeposit of mandatory duty as stipulated under 129E of Customs. It is amply clear that the direction to admit the appeal under 129E was sought for as by way of consequential relief. The High Court in the said case did not hold that the provision of Section 129E of the Customs Act to be ultra vires the Constitution of India, and having regard thereto, in my view, grant of consequential relief in a case where the principal relief is disallowed cannot be constituted as a right conferred on the petitioner to seek similar benefit. In view thereof, therefore, said judgment does not assist the petitioner. In that, the virus was upheld, and he was given that, however, he was given that benefit. So that is cannot be law, is what this judgment takes. My lord, before I go into the next judgment, my lord, I would like to place the section once. Section 129E, my lord. Deposit of certain percentage of duty demanded or penalty imposed before filing appeal. The tribunal or the commissioner appeals, as the case may be, shall not entertain any appeal under subsection 1 of section 128 unless the appellant has deposited 7.5% of the duty. In case where duty and penalty are in dispute, or penalty. So it envisages every situation: duty and penalty, and or penalty. Where such penalty is in dispute, in pursuance of a decision or an order passed by an officer of customs lower in rank than the principal commissioner of customs or commissioner of customs. And Roman 2 is against the decision or order referred to in clause A of subsection 1. No, my lord. No. No.
They have not heard my submission. They have not.
No. My lord, our contention is with regard to pre-deposit, with question of freezing. That comes in when, my lord? That he has come against an adjudication order. He is coming before my lord saying that my lord will see the prayer as specifically show that this is an onerous penalty. One, and since he can't pay that penalty, therefore that penalty, deposit should be waived. That is his main. My lord will read petition to the quashing, and then now the minute he goes into quashing, my lord will have to go into merits, which is factual merits. Yes. That the four principles, my lord. No, if he can show that, my lord, then yes, my lord. Yes. That is what on the first occasion.
Yes. That is.
Yes, ma'am. And Milaj, in my petition also I've taken arguments on merits also, apart from this one. Milaj, on the yes, procedural. I understand. Yes, I have. Yes.
Jurisdiction.
Yes. Milaj, it also Milaj can be misuse of jurisdiction, Milaj, because
no,
because yes, I understand. Yes, ma'am. Yes, ma'am.
He has to come with only within the periphery of these.
Yes, ma'am. Yes. Yes, ma'am. Yes. Yes, ma'am.
Within that, if his remedy is there, he gets here. Otherwise, he cannot get the benefit of that waiver of deposit here to go before the appellate.
Milaj? Yes, Milaj. But Milaj, there are exceptions, Milaj. On this point, on pre-deposit alone, Milaj, I am not saying that 129E stands, we have to waive it off completely. I say that upon reading it is mandatory. Absolutely true. Neither the SESTAT nor the First Appellate Authority can waive. That power has been taken from them from 6th August 2014. But Milaj, now whether 226 under Article 226, does that power go away or not? Milaj, has been dealt by courts on multiple occasions and cases fall on both sides. One, they have said that, oh, you do not meet the threshold condition. Other places, yes, you do meet the threshold conditions. So, Milaj, so in that case, Milaj, it's a case-to-case basis. Even in those circumstances, it can be divided into subdivisions. Yes, Milaj, absolutely. Absolutely. Absolutely, Milaj.
Because our courts have clearly held and gone into the point of law and decided that even the High Court cannot interfere with such.
Yes. Yes, ma'am.
Apart from this, there's a division bench also on the same point. Yes, on jurisdiction, a division bench.
That is, Milaj, most likely it is an appeal, not a writ appeal or statutory appeal.
It's on a slightly different.
Yes, ma'am.
আর কোনো judgment দেখানো আছে? Which are the judgment?
Milaj. If I may. What?
Oh, this is so. Well, there's a Supreme Court also. Since I'll finish my argument on this point. Supreme Court copy that. Oh. This is a Supreme Court judgment, my lord. This is in a situation akin again an immaterial section with recovery of Bank Recovery Act. My lord, will kindly come to paragraph 6. My lord, may I place this much? The appellant bank, paragraph 6, as well as respondent number 1, 2, 3, claiming to be aggrieved by the order dated so and so passed by DRT, have preferred appeals before the DRAT. This court at this juncture is not required to consider the merits of the rival contention relating to the loan transaction and the quantum of recovery thereof, etc., which is the matter arising in the appeal before the DRAT. The present proceeding is limited only with regard to the issue pertaining to the pre-deposit contemplated in law insofar as the appeal filed by the respondent number 1 and 2 herein before the DRAT. In that regard, the respondent number 1 and 2 herein in the appeal number so and so before the DRAT had also filed an application seeking waiver of pre-deposit amounting to 50% of the debt determined by the DRT. The DRAT, having noticed the contentions on the said aspect and also taking into consideration that the amount of 152 odd crores was received by the appellant bank, had in that context noted that the balance of the debt due works out for rupees 68 crores 18 lakhs 92,841. Hence, DRAT through the order dated 27 February 2019 directed that 50% of the said amount is to be deposited. Review filed against the same was dismissed on 9/4/2019. The respondent number 1 and 2 claiming to be aggrieved by the orders dated 27 February and 9th April approached the High Court of Delhi. The High Court, having adverted to the rival contentions and being swayed by the fact that the appellant bank has recovered 152 crores, arrived at the conclusion that the respondent number 1 and 2 are to be permitted to prosecute the appeal without pre-deposit and directed accordingly. It is in that view the appellant bank claiming to be aggrieved by such order dated 16 July 2019 passed by the High Court is before the court in the instant appeal. Now, my lord, will kindly see paragraph 9. Now that the section that this section that is in perimetry to 129. Now kindly comes to paragraph 10. A perusal of the provision which employs the phrase appeal shall not be entertained indicates that it injunct. I will not go into this, my lord. I will straight away go into paragraph 14. Cutting short the time, my lord, unnecessarily wasting. Paragraph 14, my lord. Therefore, in the facts and circumstances arising herein, when further amount is due and payable in discharge of the decree or recovery certificate issued by the DRT in favor of the appellant bank, the High Court does not have the power to waive the pre-deposit in its entirety, nor can it exercise discretion which is against the mandatory requirement of the statutory provision as contained in section 21, which is extracted above. In all cases, 50% of the decretal amount, that is the debt due, is to be deposited before the DRAT as a mandatory requirement. But in appropriate cases, for reasons to be recorded, the deposit of at least 25% of the debt due would be permissible, but not entire waiver. Now that is as per the statute, my lord. Therefore, any waiver of pre-deposit to the entire extent would be against the statutory provisions, therefore not sustainable in law. The order of the High Court is therefore liable to be set aside. And so it is very clear that that power on a provision and a fiscal provision, High Court will not have with regard to waiver of the now this, my lord, I wouldn't have. This is on the point that strict interpretation of fiscal statutes, my lord. If my lord wants, I will. Calcutta knitwears. Yeah, relevant paragraph is paragraph 20 and 24. This is 2014, volume 6, Supreme Court cases 444. Commissioner of Income Tax versus Calcutta knitwears, Ludhiana. This is on the point of strict interpretation of fiscal statute. On this point? My lord, on this point, these are my submissions. If thereafter, my lord, then I will.
I see all orders of Article 226. Just first, because I was saying complete violation of I will have to prime up. And second, it's violation of natural justice. Now, prior to entering onto what is the case, I'll briefly explain what gave rise to this case, what are the facts of the case and how I am involved as an ex-employee. Over here, I'll briefly take 2 minutes to explain what is the show cause and the demand. Gupta Infrastructure Power Limited is a limited company, which is in the manufacture of overhead transmission lines, which transfer electricity. It's situated, office is situated in Calcutta and Odisha. Over there, from 2010, I have been an employee until 2020. The company used to import a particular input which is used to manufacture its final goods called ACC composite core. The classification the assessee or the company adopted, they paid duty at 7.5%. Revenue is saying that it should be classified under another heading, and the demand over there is 10%. So differential duty they have demanded of 67 lakhs against the company, saying that these that you import are not classifiable under 7.5%. It is classifiable under 10%. You have paid duty 7.5%. You pay us 2.5% more, along with penalty against the company. In this fact, and these goods are coming from United States of America. In this skeletal framework, I am an employee. My job is very administrative and clerical. I check the import documents which the exporter from United States of America sends me, and I check whether there are any clerical errors. Is there any number different? Is there a name different? Is there an address different? Then, if they are all matching, I forward it to the CHE. In my case, in this factual context, they have imposed or used Section 114AA of Customs Act, which permits the custom officer to impose penalty equivalent to the value of goods, saying that I have aided and assisted in such violation. I'll draw your attention to Section 114AA of the Customs Act. If I may permit, if a person knowingly or intentionally makes, signed or uses or caused to be made, signed or used any declaration, statement or document which is false or incorrect in any material particular in the transaction of any business for the purpose of this act, shall be liable to penalty not exceeding 5 times the value of goods. Over here, what is the basic requirement? That I have to intentionally be aware that what classification I am adopting is absolutely incorrect. It is not classification A, it's classification B. So I have to be intentionally aware first of the correct classification, and second, that I am doing an incorrect classification due to which I am subsequently paying a lesser amount of duty. And this is a provision which has been inserted in 2006. This provision is very harsh and onerous. So harsh and onerous, that there's a standing order of the Commissioner of Customs at Bangalore, to all its junior officers, that standing order of 2024. The last page, it says under paragraph 3, paragraph 2 and 3, the adjudicating authorities are advised to specifically mention why penalty under a certain provision is being enforced and why the quantum of penalty has so been imposed. This is expected particularly in cases of penalties either at the lowest level or close to the ceiling. Third paragraph, it may be noted that provisions of Section 114A should be used sparingly in important cases as there is an inherent overlap. There are 2 penalties imposed in my case. First is 114AA and the other is Section 112 small a. Using section 114AA, Millers, they have imposed penalty equivalent to the value of the goods in mind. Millers, their contention is that I have intentionally misdeclared the goods. Now, there was a show cause notice, Millers, which has been issued, and Millers, I'll briefly go through the show cause notice because Millers, there's 1 or 2 paragraphs where allegations have been framed against me. There have been no reasons. In my reply, I have taken a proper rebuttal. That reply has been reproduced in the order, and diametrically opposite finding has been given without any other factual finding against me, whether to show that I have intentionally given wrong information or not, which would attract section 114AA. Millers, as I earlier stated, that I am a person who is involved in administrative and clerical work. Millers, they have summoned me. Millers, in course of investigation, the show cause notice, Millers, was issued on 31st December 2024. But before that, Millers, they had summoned me. And Millers, I will show that because they have nothing on record, I will just show the show cause notice starts at page 95.
May I say something? And what the endeavor where he is going into, goes into complete facts. My lord, as my lord pointed out, he doesn't therefore have anything with regard to jurisdiction. One. With regard to natural justice, that is straight away the main points that he could have canvassed before my lord. Those points he is not canvassing, and he's trying to go into the actual reasons of applicability of the penalty sections, etc. For if he has to, what the endeavor that he is going into requires adjudication of the whole show cause notice and the facts. Yes. That is there in the order itself. Yes, madam. Well, let him. Yes.
Let's page 95 of the show cause. Yes. Page 97 onwards, they start reproducing the statements. Madam, overall 6 statements have been drawn by 6 people working in the company. Nobody has said anything negative against me or showing that I have intentionally done that. Well, I will just show what I have given in my statement and what is my role in the company. Well, Mr. Malay Ketan Sahu, the petitioner's statement is appearing at page 169. It's at volume 2. This is the decided part of the document. Let us kindly come to the subsequent page 170. Question number 3. Please state briefly your role in Gupta Power Infrastructure Limited. Whom will you report to? So, if I make permission, I have joined Gupta Power around so and so as executive billing and dispatch, where my role was to prepare invoice for local sales and company packing list and lorry receipts for dispatch of the material. Thereafter, around in 2016, my designation got changed to senior executive import and export in the company, where my role became to look after documentation regarding import and export made by the company and interact with our CHA. To your specific query, the purchase orders made are placed by our purchase team with overseas suppliers, and based on the purchase order, the overseas suppliers forward the import documents to me on my email. I check for errors, if any, in quantity, value, item description, and company address mentioned in the documents received from supplier. If any error is found, I inform the purchase team regarding the same from email ID, and the purchase team informs the issue to the overseas supplier through email. If no such error are found, I forward the documents to our CHA. Then subsequent page 171, question 9. They asked me this question. Please state as to how do you verify the HSN code of the imported goods in the checklist while filing the bill of entry when you do not know the details of the product. Over here, partially they are accepting I do not know the details of the product, and they are asking how do I do it. I state that the HSN code is mentioned in the commercial invoice submitted by the overseas supplier, and I approve the checklist based on the same. These are the 2 statements that is there indicated. Subsequently, there is another statement of Mr. Kaushik Upadhyay, who is the head of projects, general manager sales. Is which please question 9. I was speaking one second. The other statement which addresses me in his summons is with Mr. Kaushik Upadhyay. Page 191, I'll directly take your lordship to that particular question of Mr. Kaushik Upadhyay as to show what is my role of Mr. Malaiketan Sauda petition. Page 191, question 9. The revenue officer asks Mr. Upadhyay, Shri Malay, looking into the import and export documents, please state the role of Mr. Malay in the company. Shri Malay, looking into the import and export documentation, part and filing import bill with the custom, he does all the port-related activities, payment of duty as well as clearance of goods. He takes help of our consultant for all the work. To your specific query, Mr. Malay only looks after import. Now, Malad, these are the only thing I record. Now, I'll directly take you to the allegations in the Shukar notice. Because, Malad, there's nothing other than these statements to show anything of my involvement into the case. Malad, the allegation against me in the show cause notice appears at page 133, Malad. Volume 1. Volume 1. Page 133. Now, Millard has seen question 9 of my summons statement where I have said I directly copy paste what the supplier provides me with regard to the HSN bidding address, supplier needs. Paragraph 21.2, if I may read. As brought out in the finding and as per the voluntary statement of Shri Malaiketan Sahu, he is aware of the technical nature of the imported goods before arriving at the classification. Shri Malaiketan Sahu was responsible for filing bill of entry for approval checklist for filing bill of entry, classifying the goods under so and so. Ketan Sahu appears to have rendered himself liable to penalty under section 114 AA of the Customs Act by way of knowingly intentionally approving checklist for misclassification which false or incorrect while filing bills of entry by GIPL. Further, Mr. Sahu appears to have rendered himself liable for penalty under section 112. So, Milad, it's silent as to how I have intentionally misdeclared. Where have I known? First, where have I known? And if at all, have I profited from knowing and misclassifying? Because, Milad, the differential duty, the burden is on the company. I am just an employee of the company. And, Milad, I am just forwarding these bills of entry, just collating data and forwarding it to my custom house agent. Custom house agent is clearing the goods from the custom port. So my role is very limited. Against that limited role, I have explained in my summons statement. The people who work with me in the company also have explained my role in the summons statement. Nothing else is there on record. Show cause notice says these words that I knowingly knew, but to fill these words, Milad, there is no evidence. Now, Milad, since it was at the stage of show cause notice, Milad, I filed my reply, Milad. At page, my reply, I filed on 3rd of February 2025. It is at page 314. Milad, volume 3. Now, Milad, at page 300, Milad, it's a huge reply, Milad. I'll just indicate the paragraphs and then, Milad, I'll show in the order in order. They have reproduced my reply. They have reproduced those portions where I'm saying that I'm not specifically aware of the technical nature of goods. But when it comes to the discussion and findings, they are just removing the not and saying, yes, I knowingly did. And I will show, and there is no evidence supporting that. I will show. It's not, I am not talking just, Milad, of my
my lord, once again say, again he is referring to the statements, etc. In the same, when in the order in original itself, the statements have been the assimilation of the statements and how it has been done is clear. My lord will kindly see. If my lord goes into this aspect, the way he is taking my lord, then my lord has to go through the whole matter. Right, right, right. Yes. So, my lord, it is very, if my lord sees the order in original itself and goes, if that is placed in toto, yes, my lord, my lord, my lord.
But at page 360, I'll directly come to the relevant portion of the order where my reply is written. The order in original starts at page 52. And where my submissions are recorded,
page 52.
52, volume 1. Page 52, the order starts, and relevant page, page 76, where my response is provided. Page 76, starting from paragraph 16.1. Shri Malay, if I may quote paragraph 16.1.1. Shri Malay Sahu stated in his reply that the include show cause notice has alleged that he has approved checklist for bills of entry with wrong classification. Further, it has stated that he has had no knowledge of technical nature of goods but still allowed misclassification action have led to suppression of facts and willful misstatement. Mr. Ketan Sahu denies all the allegations with show cause notice. He does not dispute the fact that the goods were imported and classified under so-and-so of the CPL. However, he raises the following points in his defense. That these goods were regularly imported. Paragraph 16.1.2.3. He states that his role was limited to checking import documents for discrepancy in quantity, value, item description, etc., and forwarding them to the CHA for clearance. In the subsequent paragraph, he states he relied on the HSN code provided by the supplier, commercial invoice, and had no specialized knowledge of the technical details of the product. He also added that the employee's statement corroborates has a limited role in the import process. Thereafter, I have cited legal precedents to say that I do not qualify under 114AA. Now, kindly come to page 90, where discussion and findings for personal penalty has been started. Paragraph 17.2 at page 90. Now, I will just permit me to read. Yes, sir. Permit me to read. Paragraph 17.2.1. I find that as brought on in the investigation and as per voluntary statement of Shri Malay Ketan Sahu, he was completely aware of the technical nature of the imported goods before arriving at the classification. Mr. Ketan Sahu was responsible for filing bills of entry and approval of checklist. Accordingly, I find Shri Malay Ketan Sahu has rendered himself liable to penalty under 114AA by way of knowingly, intentionally approving checklist for misclassification, which is false or incorrect, by filing bills of entry by GIPL. I also find Shri Malay Ketan Sahu has rendered himself liable for penalty under 112A. I have gone through his reply. He has stated in the reply that the show cause notice alleged that he has approved checklist for bill of entry with wrong classification. Further, it has been alleged he had knowledge of the technical nature of goods but still allowed the misclassification. His actions have led to suppression of facts and willfulness. Therefore, after he reproduces my reply, then page 92. I find that none of the submissions made by Shri Malay Ketan Sahu seems logical as far as the facts and circumstances are concerned of the instant case. I have gone through the statements of Shri Sahu, in which he himself has admitted that his role was to look after the documentation regarding import and export and to interact with CHA. He has also stated that since the checklists were approved by him, he was responsible for the approved wrong classification. Wrong checklist. If any checklist was approved based on wrong declaration. He has also accepted that these composite core were made of carbon fiber and glass fiber as mentioned in the documents of so and so. Further, and so there is nothing on record, to show. They have just continuously parroted that I have accepted in my summons. Yes. But where have I accepted in my summons? And will see, I am an employee whose net worth is 3.2 lakhs and who has been subject to penalty of 20 crore equivalent to the value of goods which were imported for 5 years under multiple bills of entry. And this is an issue of classification of 2.5%. That 2.5% differential duty is a sum of 67 lakhs. Company has gone into appeal. They don't care about me because I'm an ex-employee. Today, I have no place else to go. My first is, Milad, if your lordship permits me, I will plead the whole case and detail. But I am.
Next paragraph he doesn't. The same. The next paragraph, my lord, says gives the answer.
Milad, I will read it.
Same paragraph that he was reading. The next paragraph, I find page 92.
The subsequent paragraph. Further, it's at page 92. Further, he stated that Lakshmikanta Swen was the authorized person and the competent technical official to give the technical details about the product. I find that on being inquired in respect of sample test report, composition of ACC composite code description as Lakshmikanta said, he could not reply to the said question since Malay Ketan Sahu never reported to him and the checklist were approved by Malay Sahu only. Further, he had no connection with imports, sale, domestic purchase, domestic. So, Malay, this is nothing. Entire order in original is silent. And they are stringing me to a penalty, example, that's what I have produced before your lordship. Now, Milad, they are stringing me to a penalty equivalent to 20 crores if SESTAT will not hear my appeal because I do agree that it is mandatory. But, Milad, that mandate and that requisite of law is only subject to the tribunals and the first appellate authority. It does not bite the Honorable High Court under 226. There can be rare and exceptional circumstances such as this. And on earlier occasion also, whereas Delhi High Court has allowed on last occasion, Millas had shown Narendra Yadav and another judgment of Delhi High Court, where similarly placed ex-employee or employees of the company were subject to such harsh and onerous penalties. And the Delhi High Court waived the pre-deposit and said and ordered the SESTAT to hear the matter on merit. Millas, that is one way of going. The other way of going is to establish that there is a prima facie case that is this order is absolutely perverse. Millas, I have showed your lordship the show cause note. I have showed your lordship my reply. I have showed the summons statement. I have showed the order. Millas, the order just reiterating the provision does not make the order justified. They just merely reproducing my reply, a copy paste task, does not justify that he has acknowledged my reply. He has not. He has merely just turned statements and said, no, nothing counteracting my submissions in the reply to show cause notice. What is my role? Nobody has said that I have an alternate role. Nobody has said that I have availed any benefit illegally or there is any sort of intention as to why I have done this. I have just accepted what the foreign exporter has given to me. And this has happened over since 2018. This practice, in my statement has seen it's going on from 2018. They have started this investigation in 2022. The first shipping bill which is being issued or disputed is from 2022, 4 years after my first import of these goods. So from 2018 to 2022, it was being imported under classification A and everybody was okay with it. Then department comes and says, no, it's not A, it's B. Okay. We say, okay, I will not dispute it at this stage, but okay, there can be an alternate view. But that came after lapse of 4 years from the original classification I adopted. And in these factual circumstances, to say an ex-employee who was just doing clerical and administrative work, to hang him to a penalty of 20 crore is absolutely arbitrary, Malad. Especially, Malad, when I showed that standing order, it has said that 114A AA should be used sparingly. Because, Malad, that's why originally I had said, Malad, they have misused. They have misused 114 AA. 114 AA is a correct instrument in the hands of revenue to catch the people who are in wrong. But, Malad, they have misused it in this case. And not only misused, they have not given any justification as to why it has been applied in the first place to me. There might be a person who fits that elements of 114A AA, but it's not me because there is nothing on record. If there was something on record, my learned friend can say, oh, I'm fighting facts. But when there is nothing on record, I'm just finding an arbitrary order.
So his only argument is that this is an onerous penalty, and this is perverse. It's perverse. Ingredients of 114A are not there. My lord will kindly see the section once, and then my lord sees the relevant parts. Under 114 AA. May I please? Penalty for use of false and incorrect material. If a person unknowingly or if a person knowingly or intentionally makes, signs or uses or causes to be made, signed or used any declaration, statement or document which is false or incorrect in any material particular in the transaction of any business for the purpose of this act shall be liable to a penalty not exceeding 5 times the value of goods. Now it is in his case, he has admitted that he has been doing it. In his case, he has admitted that he is the one who does the classification. My lord, exactly, my lord, then which is why I showed the next paragraph. If he didn't have the knowledge of classification, he ought to have given it to Lakshmikanta Swine, who Lakshmikanta Swine himself says that he has knowledge of technical knowledge. Now, Lakshmikanta was his boss, higher up. One was Upadhyay and one was Lakshmikant. Now, that same paragraph, let me kindly read once again, page 92. Now, this writ petitioner himself has stated that Sri Lakshmikanta Shrine was the authorized person and the competent technical official to give the technical details about the product. I find that on being inquired in respect of sample test report, composition, HCC, etc., Sri Lakshmikanta Shrine said that he could not reply to the said question since Malaiketan Sahu never reported to him and the checklists were approved by Malaiketan Sahu. He didn't go before him. He did it himself on his own. He says that, yes, whatever the supplier has given, I have done it myself. The responsibility was his. And he has done that specifically. He himself says that I have done it. He himself says that I have done the bill of entry. And I have been doing it for the last 4 years. Now it is not something which, the finding that is not something which is perverse. But today, kindly envisage the situation, my lord. My lord, the goods are being imported. I am the person who is giving the details in the bill of entry. And I am doing this for the past 4 years. And for this particular product, I am the person who has been doing this. And we have found there are other same product being imported by others who were giving it genuinely the classification. This person had the opportunity, if he was not aware about the technical details, to go before the person in his office, in his company, who knew the technical details, to get it verified. He didn't do it.
There was no dispute on the classification. It was being imported since 2018. My learned friend is talking about a show cause notice which issued in December of
2022.
And it is starting from 2022.
Yes. Yes.
So it's not that I was aware
So
that
he has been doing it continuously. This is what the allegation is. Now these are factual issues, my lord, which is what I was saying. That ultimately this is what the finding is based on completely on facts and statements of all others. Lakshmikanta's statement, then that Kamalakanta. Kaushik Upadhyay. He himself, the accused person. Mala's own statement. Utachi Pishta. My lord, I will. No, we have marked it, yes. Again, Loki Kankota. My lord, we kindly come to page 63. My lord, 60, this is Sandeep Swine. Dated so and so. Voluntary statement dated 4th July 23 of Sri Sandeep Swine, Senior Commercial Manager, and Vijay Mishra, General Manager Supply Chain at Messrs GPIL. I will kindly see 8.6. They had also seen the voluntary statement dated 12/5/23 of Malay Ketan Sahu and appended their dated signature on the same. The contents of statement were related to imports of ACC composite core, and Malay Ketan Sahu was looking after the imports of ACCC composite core, who had already stated the facts, hence had nothing to add in the statement. But they themselves have said that it was Malay Ketan Sahu, the writ petitioner, who has been continuously giving these details. Thereafter, my lord, kindly sees next page, page 64, top. Sri Malay Ketan Sahu, wherein stated that Sri Sandeep Swine would answer the questions relating to sample test report, composition of ACC, composite code description under so and so. He stated that he could not reply to the said questions since Malay Ketan Sahu never reported to him and the checklists were approved by Sri Malay only. Further, he had no connection with imports or exports or sale or domestic purchase, domestic sale of manufacturing project of ACC. He didn't report. Malay Ketan, they specifically have given statements that it was all done by Malay Ketan Sahu. Now, my lord.
My lord, where is it which says that it was all done by Mr. Sahu? Yes, reading a paragraph.
That is, yes.
My lord, page 64 does not say so, my lord.
Yes.
Yes, my lord. My lord, checklist is, my lord, the documents based on which the bill of entry is filed. That I used to get and I used to post it to the CHA. I have said it in my statement.
Yes, that is what you have
It's
done.
not that I've intentionally misclassified the goods. Where is the intention? Where are they saying that I have knowingly?
Yes.
Yes, sir. No, absolutely. But there might be. But absolutely not, Milad, because I report to the project manager, Milad. Mr. Kaushik Upadhyay's statement has said that my job is taking care of import and export, Milad. I, in my statement, have said that my role is to develop the checklist, which consists of the invoices of the foreign exporter along with the. Absolutely not, Milad. There is no point like statement, Milad. Absolutely not, Milad. I will show because there is no statement. This statement does not justify anything, Milad. Because I see to the point that I have formulated the checklist. I am handling the bill, the invoice which is supplied by the foreign exporter. Milad, to check whether there are any mismatch in clerical details or not. Milad, I have said that. Milad, because I will. Yes, Milad, because my salary was around. Milad, the technical specification of these goods is handled by somebody else. I will show by the statements. Milad, I revert to my senior, Mr. Kaushik Upadhyay. Milad, there is a statement of Mr. Lakshmikanta Swen. He is the technical executive. Milad, his statement is on page 146. It's on volume 1. It will see, Milad. It stretches for almost 20 pages. He gives description of imports, exports, everything. But, Milad, I do not have all that knowledge. A technical person will have that knowledge. I am not a technical executive. Today, I am just an employee doing some clerical work. That does not mean I will know that these goods are classifiable under chapter 85 or chapter 68. That knowledge I do not have. No facts, no statements point to this admission that I was aware that, okay, these goods are not under 85, it ought to be under 68. If I'm reporting to someone, let the senior officer tell me that what you're doing is incorrect. Everybody knows in the company, from the junior to the senior most person knows what imports are taking place. If my learned friend, no, that's what there is no evidence. Well, I do not. Well, I do not intend to disrupt Miller any by shouting Miller, but I am shouting Miller only because of desperation, because I am being hanged. Yes, sir. Absolutely, absolutely. Miller, the only point I'm saying. I can deal with it, those points, whether they are actually pointing to an element which justifies 114 AA. Because Miller, the paragraph by clear said that is one paragraph that he has got. I will come to that. But apart from that, I showed my lordship the paragraphs of the chauffeur process. What? Based on what evidences they recorded as on December 7th, what gave them to this opinion that 114 AA is applicable or not? Milan, only thing they relied on was my voluntary statement. I gave them my reply, Milan. I told them my goal. Milan, I also told them what is my salary. My salary was started from Milan around 2.8 lakhs. The last salary I withdrew was around 6.2 lakhs for the company. Milan, I explained my role in the company. I also stated that this particular classification, Milan, is of technical nature. Why I say technical nature? Because I will go a little bit more into this, Milan, just on the surface, is right.
Any day next week. I think he will have to now deal with it. If my lord wants, on the next occasion, I will place the statement of the writ petitioner. It itself makes it very clear that he was the one who was doing it, and I can place the statements of the other two persons, which show that this writ petitioner only has been doing it. Now the question, what he was saying, is that how can you say that he knew it and he then did not do it? That is something one can only bring out. That is something which, yes, knowingly and intentionally. So that is what my endeavor was, that when I said that he had an opportunity to take the technical knowledge and the technical aspect from the person who has given a statement that he was a technical person and he could have done it, and he did not approach. What he says is, writ petitioner says is that I have got this thing from the commercial invoice of the international importer, and based on that I have made this. Now this is not the system. The system is, the classification is done by the importer. He was the importer. In fact, he was the one who was the face of the importer. He was the one who was instructing on putting the classification, putting all the details, every detail in the. No, he has said in the statement he knows. No, he says that the classification that he has given, he says that I don't have technical expertise, but I have given it on the basis of what the commercial invoice has said from the overseas buyer. On that basis, I have done. Now, that is not the system, madam. the product that is given is what in the invoice the product is given. In what classification it will fall, it is for the importer to put in with the active help of the clearing and forwarding agent. This is the actual system that is followed here, is the importer has to put in the classification, and for that the clearing forwarding agent helps it. Now what he is now saying is, no, I didn't have any intention to do this. I didn't have any knowledge because I'm not a technical person. Now, if you are not a technical person, then why did you put it there? Why didn't you go to a person who is a technical person? And how come there was a clearing and forwarding agent? Once you have given the classification yourself, only then it has moved ahead. And that was the strategy that was going on for 4 years, my lord. And that is what, based on the statements,
Just point out one important part. Whether it was correct classification or incorrect classification, only came to knowledge when the show cause notice was issued. And the show cause notice has been initiated by the Customs Authority in Kolkata from information arrived from Customs Authority in Chennai. So,
yes, that's
the
how.
point I'm trying to make is, for me, at
The calendar,
November of 2022, 24, to me, I knew that the only classification is classification A. Only in December 24, they say, no, it's not A, it's B. So,
my lord takes it up next week sometime.
The past over matter item 6, can it retain its position tomorrow? Great. I let my your lordship must be now accommodated, my lord, in the other building. Because of this determination being, my lord, an important one. My lord, people, my lord, benefit.
Yes. Yeah, that definitely. No, when we have to go that side and roam around and come here, it becomes same what he faces once in a while. We do it almost every day. Same thing. Yes. No, we are happy with my lord here. My lord.